Good afternoon, everyone. I'm going to go ahead and call the session now. We're running about 5 minutes over, and I want to get us back on track. I've been asked by Rita to remind everyone to please fill out the appropriate forms at the table in the back if you're participating in the conference today. We only have about half of the people have signed the required form so far. Hello, everybody. I'm Ella Callow, and welcome to our third panel, Challenging Processes and Procedures, Changing the Landscape for Persons with Disabilities. I'm going to introduce each of our inspiring speakers and note their full biographies are available for you on the symposium website. I'd like to thank Laverne for the opportunity to moderate today, and both she and Rita and everyone else that's helped facilitate this wonderful event. First speaker today is going to be Alok Chatterjee. Professor Chatterjee joined the Faculty of Law at the University of New Brunswick in July 2003 and is currently Associate Professor of Law. His scholarly interests lie principally in the fields of constitutional and human rights law, especially issues of disability and policy. He's presented his work in connection with programs organized by the Canadian Bar Association, the Canadian Institute for Administration of Justice, the National Judicial Institute, and the Canadian Law and Society Association, among others. From 2005 to 2014, he served on the New Brunswick Division Board of the Canadian National Institute of the Blind, Canada's leading organization devoted to promoting health, vision, and independence for persons with vision loss. In 2010, Professor Chatterjee completed a 3-year term as a member of the New Brunswick Human Rights Commission. Since 2011, he has served on the board of the Canadian Civil Liberties Association. His paper today is entitled, Can We Advance Disability Rights Through the Class Action? Our next speaker will be Carrie Basis. She is currently on adoption sabbatical from full-time law teaching. Ms. Basis practices appellate civil rights, labor, and employment law in Seattle, Washington, and is a Master's of Education candidate in Educational Policy, Leadership, and Policy Studies at the University of Washington. She's taught at the University of North Carolina School of Law, Penn State University, University of Tulsa College of Law, Case Western Reserve University, and St. Joseph's College of Maine. She's been a visiting researcher at the University of Virginia and a postgraduate research fellow at Harvard Law School. Professor Bassis's research and advocacy focus on disability rights, health equity, anti-discrimination, and ethics. Her recent scholarship on regulation and health has appeared in journals such as the Kentucky Law Journal, Utah Law Review, and Working USA. Ms. Bassis recently identified Title II violations occurring in the city of Seattle's youth programming and was successful in bringing the city into compliance. Her paper is entitled Advocacy, Fatigue, Self-Care, Disability, Discrimination, and Legal Attrition. Dr. Laverne Jacobs will be presenting next. She currently holds a Fulbright Visiting Research Chair in Canadian Studies at the University of California, Berkeley. She's a visiting scholar at Berkeley's Law Center for the Study of Law and Society. Dr. Jacobs will now return to Windsor Law, where she's taught since 2007. She's a recognized administrative law scholar. Her research interests include the independence and impartiality of administrative actors, human rights law, disability rights, access to information and privacy, comparative administrative law, and qualitative empirical research methodology. Her work has been cited by the Supreme Court of Canada. She's held public appointments, including acting as a part-time member of the Human Rights Tribunal of Ontario between 2005 and 2010, and is a recipient of many awards, including the Nicole Kingsman Fellowship in Administrative Law and a Young Academic Scholarship from Cambridge University and the Chinese University of Hong Kong. She will be presenting Do Disabled Voices Matter? Exploring Equality and Fairness in the Enactment of Accessibility Standards in Ontario. And finally, we have Stephen Rosenbaum, JD, who is a lecturer at Berkeley since 1988. He currently teaches a core policy course at the Goldman School of Public Policy and regularly offers disability rights courses at Stanford Law School. Until 2013, Mr. Rosenbaum was of counsel to the San Francisco law offices of Michael S. Sorgens and has been a staff attorney with Disability Rights California, a senior litigating attorney with the Disability Rights Education and Defense Fund, and a longtime litigator with the law offices of California Rural Legal Assistance. In 2012 to 2014, Mr. Rosenbaum was a visiting senior lecturer appointed at the University of Washington, where he co-founded a business and human rights clinic and co-taught a clinical tutorial for LLM candidates from Afghanistan and Indonesia. His scholarship is in the areas of education, disability, lay advocacy, international human rights, and clinical education. He was awarded a Wasserstein Public Interest Fellowship at Harvard Law School in 2002, and in 2013 was the recipient of the Eleanor Swift Award for Public Service. His paper is entitled Something in French that you made difficult for me, Steve.
I'll use my best feedback.
Oh, please do.
Les enfants en difficulté.
A radical.
No, sorry, une procédure en difficulté.
A radical blueprint for resolving special education disputes through the inquisitorial process. So, having introduced our panelists, I will turn it over to Professor Chatterjee.
Okay, great. Can everyone hear me? Well, Laverne's maneuvering the microphone. Okay. And can you just tell me when I have about 5 minutes left? I don't want to be responsible for taking us off time since I'm the first speaker. Okay. So my presentation today, is an attempt to answer the question if we can advance disability rights through the class action. And although I've posed this question, I might disappoint some by only giving you a tentative answer to this question. And a tentative question because I think, in some ways, the jury is still out. But I do think that from what I've studied so far, I think one has to be cautious in characterizing the potential of the class action to advance disability rights. And this may be a bit surprising, particularly to some of our colleagues in the United States, where there is quite a lot of literature commending the class action as a vehicle to advance disability rights, particularly if one adopts a more robust theory of group-based disability discrimination, and if one adopts a more proposive approach to the slightly tongue-tied, proposive approach to when the courts are applying the requirements for class certification. So you're probably wondering why, since class actions in Canada are probably not all that different from class actions in the United States, at least from a procedural point of view. In fact, the American experience in some ways provided a useful backdrop to the current legislation that we have in many Canadian provinces. My hesitation, is therefore a bit surprising, at least when I presented this in draft to some other people. They were surprised that I was being such a, quote, downer. But nonetheless, here are my observations, and I welcome your comments and criticisms. For those of you who do follow Canada, you probably know that there is a wide debate, and wide but perhaps not deep debate about access to justice and what it means. Our Chief Justice has taken a leadership role in this area and has actually appointed one of the members of the court to lead a task force and make recommendations about promoting access to justice when it comes to civil cases in Canada. This has prompted me to ask, what does access to justice mean from the point of view of disability rights, or more particularly, from the point of view of participants with disabilities in the civil justice system? Now, so while this term, access to justice, and this concept, I'll be kinder, I'll call it a concept, I won't call it a term. The concept, is contested and its content is somewhat unclear. We have seen the Supreme Court invoke the concept in a number of significant procedural rulings relating to the class action. And I think the way that the concept of, quote, access to justice is being used causes me to pause. I'm going to focus my comments on two cases, which I think are important in the Canadian context. One is a case called Rumley against British Columbia, which was a class action to seek redress brought by students at the former School for the Deaf and Blind in British Columbia. And at the time, the fact that on appeal to the Supreme Court, the court unanimously granted certification and allowed the case to proceed, it was seen as a very good thing, a very promising thing. And I've always been troubled by that. And it was only last week when I finished teaching my last course in civil procedure. In addition to disability rights, I focus on issues of judicial process. So I was teaching civil procedure, and we concluded with the class action. And students of civil procedure will know that the class action is desirable from a policy point of view because it fosters access to justice, judicial economy, and behavior modification. And it comes at the end of the way the standard Canadian civil procedure course is taught. And if you use the leading casebook, you'll see that Rumley is prominently displayed in the casebook. And I don't mean this to be a criticism of the casebook authors, but it's there with its discussion of access to justice and the promise of the class action, and it's there, and it's kind of a feel-good way to end the course after you spend a lot of time looking at the barriers created by all the various technical components of procedural doctrines. And then as I taught it that time, I realized that I actually don't buy it. And I actually felt uncomfortable because it was an oversimplification. And in fact, the case shows why the class action is problematic. And in my time here, I want to tell you sort of 3 reasons why the case exemplifies why the class action has limitations. Okay. First and foremost, it is questionable, right, whether the Supreme Court deserves all the praise it received when it granted certification, and it was seen as being very open to the concerns of persons with disabilities. The reality, if you look at the case in full when it's reported, and perhaps not as it may be edited, right, we can see that the heavy lifting, the work that permitted the certification was done in a different proceeding. Had there not been a public inquiry established by the government to look into the conditions at the school over the several decades since it was established, the court, it seems to me, would not have granted certification. From a procedural point of view, the court had to struggle to find a common issue justifying the certification of the action. And the fact that the relevant standard of care varied over that time period would seem to provide a serious obstacle. But because there was this public inquiry, led by a distinguished member of the profession, Thomas Berger, right, the court was able to design the subclasses to create the commonality because it was able to build on the difficult work that the public inquiry had. Right? It seems to me that if there was no public inquiry, the court wouldn't have been able to find a procedural way to do the certification. And so if we really think about the class action being a device to promote access to justice, at least in this high-profile case, really we have to give much of the credit to the public inquiry and the public support of the public inquiry. Right? Without that information, no matter how talented the lawyers were in the case, they would be unlikely to come up with the factual basis and the evidentiary basis to support certification. So that's number one. So the class actions alone does not remove the structural impediments to getting the information necessary to certify the class. The second point, and I think this is very difficult, it relates to what in procedure is called the preferability analysis, whether the class action is a preferable vehicle for advancing or for resolving the legal claims. And here, the court was persuaded that certification was desirable because of the extreme vulnerability of the claimants and the perceived difficulties they would have in accessing the civil justice system without the procedural benefits of class proceeding. And this is true, and at a certain level, the plaintiffs, and the representative plaintiffs did achieve litigation success for the class members, right? But the problem is that success came as a result of stereotyping. It just happened to be a stereotype that worked to the advantage of the representative plaintiff in this particular case. It seems to me that there was no attempt, and indeed there was no opportunity, or perhaps even the desire, for the court to identify with some precision what the barriers were for the participants with disabilities in accessing the civil justice system. Right? And so if the class action and the ruling is to have guidance for other courts, because the problems weren't particularized, there was no guidance on how these procedural barriers or barriers in the civil justice system, how they should even be addressed. It was just a very easy thing to say that preferability is satisfied because of the vulnerability and difficulty faced by the plaintiffs without specifying what those difficulties were. And if part of why we bring equality litigation, why equality-seeking groups bring civil litigation in the first place is actually to dismantle stereotypes, it doesn't seem like a very practical or very desirable strategy to actually embed stereotypical thinking in the law itself. And I'm reminded of Professor Tenbrook, who said that the law should be developed with the idea of fostering integration and inclusion, right? So this is a positive result for the particular claimants involved, but it does nothing to actually foster inclusion in the civil justice system. And without fostering that inclusion, I don't think the class action will necessarily achieve its desirable results. Just how am I doing for time?
You're not even to 5 minutes left. You're fine. Yes.
Okay. And then access to justice, though it's invoked to promote certification, sometimes the way that the Supreme Court has developed access to justice, in the way it is, at least in Canada, has developed procedural doctrines such as something that we have in Canada called the rule against collateral attack, which is, I admit, it's not a very sexy topic, but when this rule is invoked in a way to deny claims by participants with disabilities, and when the rule functions in a way that might have adverse effects to claimants with disabilities, I think we have to look at it more carefully. The rule against collateral attack is sort of a bedrock principle. It sort of determines when one can sue for damages, right? So a private cause of action, breach, negligence, tort, breach of contract, and get damages. And when one must pursue judicial review to challenge executive or administrative action. Right? And in Canada, there has been the concern that when the private cause of action is based on the wrong of a governmental entity, so for example, a denial of a benefit, an unconstitutional incident, right? When does the claimant have to seek judicial review prior to initiating the case for compensation? In other words, do you have to do that? And the Supreme Court says that access to justice would be facilitated if you just didn't have a multiplicity of proceedings, and instead that provided that the claimant pleads the correct elements and the pleading produces the, as a matter of law leads to that whatever remedy is sought, everything is generally fine because they can adjudicate the lawfulness of the governmental action inside or embedded inside the cause of action. And so far that sounds good. Multiplicity of proceedings, why should persons with disabilities have to go through more stages? Okay, but here is the problem. Unless, of course, there's this problem of the artful pleader that is really disguising a damages case into a judicial review case to say, get a public law remedy like a structural injunction. So in other words, you can sue for damages as long as you're willing to keep the administrative decision intact. But if you want to undo the decision, say by getting a declaration, as opposed to compensation, then you have to go through judicial review. Okay, and here's the thing. And the Supreme Court said you have to determine what's called the essential characteristic, or the essential character of the proceeding. And the thing is, the essential character of the proceeding, it all depends on whose perspective you answer that question from. So, another case from British Columbia, but this time a trial-level case, dealing with an attempt to get damages. This time the case was brought by parents of children with disabilities, more particularly children who were on the autistic spectrum. They sought to combine to get two things. They wanted to get damages because they had to pay for those services out of their own pockets. So that would have covered things up to the present time of the action, plus a declaration that they were entitled to future state-funded benefits. Okay? And their case for damages was halted because they said this was a thinly disguised attempt to get a public law remedy, that really the effect of the action would be to compel the government to provide funding, and that was not possible. But it seems to me, if you apply the essential characteristic test from an able-bodied point of view, then maybe the thing is quite rational. But if you apply the test from the point of view of the persons with disabilities who are, the claimants or the beneficiaries of the proceedings, or for whose benefit the proceedings are being brought, this distinction, this essential characteristic test falls apart. And it seems to me that from the point of view of those people, they need to get from their experience, they need both, and they can't get both as the doctrine is currently structured. And so if we are to solve what Diane Poitier has called perhaps the most difficult problem for disability law, we have to address the structural barriers created by able-bodied norms embedded into our law and institutions, right? And for that, unfortunately, I think that access to justice and the adversarial process that surrounds class actions may be a less useful tool than is conventionally thought. But perhaps I'm just a glass is half empty kind of person. We can discuss that in the question and answers. Thank you.
I think Carrie's going to begin next.
Okay, great.
Okay.
I think this is on. No. That's better, I think. No, it's, oh, there we go. It took a while. It's a little bit of a lag. Can you hear me? Okay. Thanks so much for having me. Thanks to Elizabeth Pendo for providing comments on the paper. Today I'm going to talk about advocacy fatigue. I'm playing a little bit with the title. My current working title is Self-Advocacy Fatigue, : Everyone needs a subtitle. That's version 1. No, just kidding. Self-care, protest, and education equity. So I figured that I would be a bit mundane and talk to you about the first half of my week, which I'm sure you find so exciting. I filed civil rights complaints with the U.S. Department of Interior, the Department of Justice, the Office of Civil Rights for the City of Seattle, and the Human Rights Commission for Washington. I then navigated communications back and forth about establishing an accommodations procedure for a child who had been denied childcare at a local community center based on her short stature, limb differences, and platelet disorder. I attended and advocated at an IEP meeting, before which I had individual consultations with 3 special ed teachers, 1 OT, 1 PT, 1 speech and language pathologist, and then an independently hired clinical social worker. And this process was entirely amicable, but I became an expert on making goals observable and measurable, pronunciation patterns, my own, of ELL students versus what's a speech pathology, toileting devices, which I just started to call the butt devices. There's a specialty market in people who make butt tools that are for wiping, which is an important step to independence. But, you know, they did bring some giggles in our household as I was like brandishing them about, and our 5-year-old was getting a hold of them. My parents were visiting. They were like, what? What is that? That's just sitting on your coffee table. Dressing sticks, the appropriateness of certain social, emotional goals, and problem-solving strategies for kindergartners. The Common Core, because we love that in Washington too. And first grade readiness. Now, I'd like to say that I got paid for all of these tasks in my very lucrative job as a lawyer, but all of these tasks were for my daughter, and there will be no billable hours. These are things I do in addition, I'm not special, and you know, these are things I do in addition to working, to being a partner, to going to school full-time, to having outside interests. Like, I've never been able to really knit a sock. I can only do washcloths because I don't have the attention span after this. And so I was thinking about this. You know, I'm pretty privileged, well-educated, junkyard dog, if there's going to be one. And I feel screwed a lot in the system. And what I see is pretty obvious. In education policy, we talk about things that happen to educators. I love educators. I need them. But we're not really talking about the experience of what's happening to families and therefore to students and the strains. And that seems so obvious. And in fact, I almost didn't write this paper because the subtitle could be, duh. I mean, this is really, but why is this not out there? I'm either a genius or I took an easy way out. But it just keeps happening. And so I keep hearing these stories, and I worked this summer a bit for the education ombuds for the state of Washington on issues facing special ed students and limited English proficient families in Washington. And we're taking some legislative efforts and trying to get some funding to make our programs better and to tackle special education through improving general education and the training of general education teachers and administrators. But all of this remains to be seen as to how effective it will be, and it is certainly a long haul. And we're talking about effects that will happen after kids that are in kindergarten will graduate. Talking about sort of the next generation. And so I really want to talk about the reality of marginalized families in the system. And, you know, my particular lens in this paper, which I won't focus on as much today, is on ELL students and students with disabilities. But in general, I'm interested in marginalized students. And I think those are 2 very good examples of what marginalization looks like. I mean, briefly, I'll just say that the overlap there, as I've really seen it, is that we don't expect students with disabilities to really contribute much after school. We have very low expectations, and therefore we can meet very low bar for goals. And the same is true of ELL students. I mean, this sense that there are higher needs, that we have to make more of an investment, there's a calculus that goes on that doesn't go in their favor, is saying that's worth it. And so there's also this lack of literacy around how do we best serve students in either population, and just a fear of litigation. And so you see processes shut down. So when I was looking at ed policy as what the education literature talks about, it's really about burnout and compassion fatigue among educators. I think that's important because we want good people to remain in the system. If you look at my daughter's kindergarten, for example, which is a lab school at the University of Washington, you see a lot of young women in the profession who will go on and be ABA specialists or maybe go to a private school focused on kids with disabilities, but they're not going to be there for the long haul. It's a place that they pass through and they hope that they can convert it into a better job later on. They're not sort of going out into the wilds of Seattle public schools for the most part for the long haul. So, I was really interested in this idea of higher needs and poorer services and stereotypes about the lack of a contribution to the system, as well as the additional strains of SES. I mean, we're talking with marginalized families about students and families who are already suffering in the community in many ways, are already overloaded, already disadvantaged. And then we're taking them into these complex legal negotiations and advocacy settings in which they're supposed to instantly have a JD, instantly be specialists in speech and language pathology, instantly be able to describe what is a normal pattern of, say, acquiring English as a second language versus a disability, understand what their educational rights are, understand where to find community resources. They may not even be available in their own languages. And there are compromises that go on for families to make this work. And I see those compromises among my pretty privileged peer group, and we often say, God, this could be so much worse. Like, we are screwed, but we are not as screwed as we could be. And that's the thing that we hold on to, which is pretty sad. But we recognize our privilege, and we're like, this could be so much worse, but this is not good. I was interested in what this looks like. And so I wanted to think about the system as it exists. So we have the school system, which has built-in professional knowledge, and I would say a privileging of that professional knowledge, a hierarchy. And we know that involves difficult terms and expertise and just sort of understanding even the language in which the schools communicate about students and their needs and what they're able and willing to provide. Parents, on the other hand, mostly learning as they go. They're unfamiliar with this language and the procedures. They already start out as disadvantaged because they don't usually have the same professional training and background as teachers and principals. They have a lack of clarity about when their rights are breached and what their rights actually are. In our study at the Office of the Education Ombuds in Washington, we were doing focus groups with limited English proficient families this summer. We found out that most of them, and this is probably not surprising to this audience, rather than getting interpretation and translation through the schools, would just bring a family member or a community member or the student themselves, even if it was a discipline hearing, to do the translation and interpretation, rather than rely on the district to provide those services. Oftentimes the districts would play games and say they couldn't do it, or we can have somebody at the meeting for 30 minutes who shows up 15 minutes late. So by the time you've reviewed some of the paperwork, you don't even have a substantive conversation about the student. And then they would be expected to kind of know enough English or know enough about the process to proceed in a meaningful way from there. The school system, the responsibilities are paid. And, I spent the other half of my summer working for a labor law firm, and so I will not say that I think teachers are well compensated, but I will say that there is some money there. And what you see on the family side is this is care that is not paid for. The strains at school cause greater strains on employment relationships and some decisions that most people would not like to make. Taking on greater needs and demands on a school schedule for meetings, for getting up to speed on understanding the education system comes at a real cost. There are financial ramifications. And we're talking about, if you have the luxury of being in a two-parent working middle-class household. And beyond that, and the strains are even greater where people live in marginalized jobs, part-time positions, contract or seasonal work in which very much attendance at work, seeming like your regular, routine, accountable employee are really important facets. And so it's very hard to explain to your employer whose salary you're counting on for supporting the rest of the family that you have to go to a school meeting. That you may not even understand what's really happening at that meeting. School systems have built-in legal support. The quality of it is not often great. I would say, just to be fair to teachers and principals, it's an astounding lack of legal knowledge, although sometimes they don't act as if they have a real deficit in legal knowledge, but we don't usually expect this. I could say this about the University of Washington in our teacher training programs. We don't educate teachers. If we do, they get a 2-credit class in special ed. It's optional. Yet studies have shown by other researchers in the social sciences that the largest area of inquiry about legal processes in schools is about special education and then ELL learners and what should be provided and what the legal rights are and what the procedure looks like. And so teachers and principals live in fear that these issues are going to come, that they come on a weekly basis. You know, the highest level of threats from families about litigation or stress about litigation for schools is in the area of special ed, at least some studies have documented. Yet, you know, we have administrators that exist even further up in the system that are really not well prepared to deal with this. And so that can really shut down conversations. We know that parents are not usually lawyers, unless you're in my mommy's cocktail group, which is a little distorted. We learn from an informal system of parents, if there is one, and I would say that that is certainly a privilege as well, to have an informal network of knowledge to learn about schools, particular classrooms, service providers, outside experts, all of those things, if you can really rally for them. But that is not generally how people operate. They, incidentally get information. In the best circumstances, that network of community resources can be really supportive, but it doesn't mitigate the alienating experience of having to gear up for what could be a conflict that goes into litigation. And I think that's also been an area in the literature that we've really underexplored as to how litigation stress affects the litigants. I saw that there was a great literature on how judges feel about the people coming through their courts. Love judges. I don't really care so much about how you feel about it. As long as you're getting in touch with your stereotypes and biases and making better decisions, you can pay for someone to deal with your mental health. Save that for another law review article. But, I'm sorry, that is not my pecking order for who I care about, how they're dealing with this process. Lawyers, too. And I taught professional responsibility for years, so I do care about keeping good people in the profession. It's so critical to having the right outcomes in cases. We really need to think about the effects of litigation, not only on the actual litigants, but the community in which they exist, in which people are waiting for outcomes, or waiting to get a sense of how things might turn for them and what the policy implications are. I'd say schools are really geared towards individual resolutions. You go through the process, you might have a grand vision about what systemic reform might look like, and in the end, lots of things happen behind closed doors that are quite quiet about this is the thing that we're going to do for, if you're successful, that we'll do for your child right now, this year, in this particular space. Beyond that, you might have to do this again. We're not documenting this anywhere in a way that's enforceable. Do you want this now? And you've been worn down. So it's definitely a game of attrition. And I would think that schools, as daunting as it is to be on the other side of the process, conflict for them becomes often routinized and familiar, and for families and students who have to still exist in the communities in which they're having a conflict, the school community, it can cause great upheaval, and it really is a game of attrition. So I only have a few minutes left, and I think what we have talked about in the literature about families and students in education advocacy has been about good parents versus bad parents, good families, good students versus bad students and families. It's a hugely racially biased and class-biased literature in which we don't really capture the different ways that people care and invest and represent in conflict. Even there are huge class differences in how students are taught to deal with conflict in the classroom, and for higher income families, that looks more like addressing things along legal lines. And for lower income families, there's been some studies coming out of Indiana, for example, it's to avoid conflict. And so there are huge cultural ramifications for just assuming that everyone engages in conflict in the same way. That everyone has the same advocacy skills and material resources to bear conflict, and this difference between individual and systemic vision. So I'd like to move in a direction of thinking about advocacy fatigue, and my working definition is the increased strain on emotional, physical, material, social, and wellness resources that comes from continued exposure to systemic inequities and inequalities, and the need to advocate for the preservation and advancement of one's rights and autonomy. And we could add interdependence there as well. And talking more and encouraging the education and law literature to talk more about what that looks like in terms of the drain on families' emotional and physical health, their career prospects, their relationship to community and schools, financial security, because all of those things in protracted conflict have fallout effects. So what do we do to help? And this is where I could really use some of your help. I think first we talk about it, which is great. But we also have to recognize that families and students are de facto policymakers, and how do we support them in doing that, in a systemic way and connecting with others, and understanding and exploring more the way in which families and students are informed by culture and contribute to school culture itself, and understanding how stigma affects the entire family system and the community. So people bear not only their primary stigma, but stigma through affiliation and relationship and courtesy stigma. And I just find that to be a fascinating thing. So it's not just what's happening to the student, which is really important, and it's not just what's happening to the parent. And I should say as a side note, I never really cared about special education, even though I was a product of segregated special education until 3rd grade. I went to school for kids with disabilities, because I always thought it was antithetical to my disability rights perspective, because we were talking too much about parents. So I found Bonnie's presentation really interesting. The last thing I wanted to talk about was how hard it is for parents of kids with disabilities. I'm like, what about the people with disabilities? You know, the parents, I mean, come on, usually they're like able-bodied folks. They're down on my sympathy list too with the judges, but I'm not going to get a job anywhere ever. But, the thing is that stigma transfers, and it's amazing in the way in which people become proxies for one another, and they share in that. And there's that emotional connection of parenting I didn't quite get until I was a parent myself, and I was quite pissed off. So you have to subvert the hierarchy of professional knowledge for sure, and jargon, but we really, so much of the school literature talks about a democratic vision of schools, and it's just such BS, because we really don't involve community groups and family participation, or students with disabilities and alumni participation. Why is that so foreign? I think we need to think about professional retraining. Some of that has to do with values. I mean, how students with disabilities and their families, students who are bilingual emergent English language learners, come to understand their identity and what it means to them instead of a deficits-based approach. I mean, deficits are helpful in getting minutes for service, but not necessarily in terms of fulfilling this vision. So I'm really interested in your ideas, too, for making dual capacity in schools between families and communities. Thanks. What? No, she was flagging me down.
Okay, thank you for the kind introduction, Ella, and I'm very pleased and very honored to be on this panel with such fabulous presentations. And I'm also I realize that coming at this point in the day, it's I have several hard acts to follow. So anyway, what I'm going to talk about today, the presentation that I'm giving, forms part of a larger ongoing qualitative research study called "Do Disabled Voices Make a Difference? Exploring Equality and Fairness in the Enactment of Accessibility Standards." It's a book in progress, and what I'd like to do in my brief presentation today is to say a few words about the larger research study first, and then focus more specifically on one issue that I've recently examined empirically in my work relating to transportation inequality and how claims for disability discrimination in transportation have been handled by human rights tribunals in Canada. So let me begin by making 3 main points about my overall research project. First, my research is an institutional analysis that examines from different perspectives the shift to adopt a proactive approach to addressing disability discrimination. The proactive approach that has taken place in Ontario and also most recently in Manitoba consists of the development of accessibility standards with an enforcement mechanism to ensure compliance. In Canada, as in most jurisdictions in the world, the traditional approach to addressing disability discrimination is reactive. That's to say, it's an approach in which individual or collective complaints are brought to a responsible body, such as a board, a tribunal, or a court, and the matter is adjudicated. Excuse me. The second point is that it's important to note that the move to adopt proactive regulation in the provinces that have done so does not mean that the reactive, complaint-based human rights mechanism has been abandoned. By contrast, the two approaches are meant to complement each other. And the third point that I want to make is that my overall research project looks at the concept of voice and the circumstances that allow for voices of persons with disabilities to be heard within their pursuits to achieve equality through the legal system. The first part of the research project considers this issue within the human rights decision-making process, and this part of the study is being completed through a documentary empirical analysis of disability discrimination claims. The second part explores the circumstances that allow for persons with disabilities to voice their concerns and be heard in lawmaking processes. And here I am looking in particular at the consultations leading to the development of the standards. This second part is being completed through qualitative empirical engagement with various actors in the field, such as persons with disabilities, organizations dedicated to disability issues, and institutional government actors. Okay, so I'd said that I would talk about the larger study and then turn attention to one issue that I've recently finished examining. This issue is transportation equality for persons with disabilities. I've been examining human rights tribunal decisions since 1982 to try to unearth some of the challenges to using the system faced by complainants with disabilities. 1982 was chosen as the starting date for my sample of cases because it's the year in which disability was first included in a human rights statute in Canada as a prohibited ground of discrimination. That statute was the Ontario Human Rights Code, but you should know that disability is now a prohibited ground of discrimination in all human rights statutes across the country. July 2014 is the end date of the sample period. I think it goes without saying that transportation is the lifeline that connects persons with disabilities to the community. It facilitates greater opportunities for work, social inclusion, and overall independence. Adequate accessible transportation has long been a concern of persons with disabilities, yet there really isn't much sustained research on the law and society implications of transportation inequality for persons with disabilities in Canada. A review of the decisions dealing with allegations of disability discrimination in transportation reveals some interesting facts. First, there have been 53 cases over a 32-year period. And this is the only time I'll use my slides, actually. If you have the printout, I'm going to just go forward to slide 5. So there have been 53 cases over the 32-year period that was examined. And 53 is a relatively small number of cases. By comparison, consider that in the 2013-2014 fiscal year alone, there were over 3,000 applications filed at the Human Rights Tribunal of Ontario. And in 1982, 22 files were heard by the HRTO's predecessor, the Board of Inquiry. Why such a small number of cases? Well, it may be a reflection of a number of things, including the expense required to adjudicate a matter before a Human Rights Tribunal and the statistically disproportionate number of persons with disabilities who live below the poverty line. Second, a review of the cases also shows that there are very few successful cases. Discrimination was only found in 23% of all the decisions that I examined. By contrast, the majority of the cases were held to be unsuccessful on the ground of discrimination or did not even make it past the preliminary stage. Third, the review shows that more than half of all transportation cases were brought by self-represented litigants. And in some jurisdictions, such as Ontario, the number of self-represented litigants was really quite high. In Ontario, 79% of the cases were brought by self-represented litigants. Overall, from my analysis of these cases, I argue that the approach to legal interpretations of human rights legislation has remained tightly wedded to narrow constructions of equality. As a result, the use of statutory human rights law remains resistant to affecting social change, particularly in the realm of accessible transportation for persons with disabilities. And I argue further that voices of persons with disabilities who are complainants are therefore lost in their attempt to navigate and obtain redress in the litigation process. So in reviewing these cases, I was able to classify them into 3 categories. And I've indicated the categories up on the slide. I'll indicate what they are here as well. The first is claims seeking transportation restructuring. The second is claims seeking access to transportation in support of a broader family dynamic. And the third consists of claims in which the complaint is prompted by a conflict or incident that occurs while using the transportation system. And I just want to stop to make a point here that part of the reason why human rights tribunal cases are so interesting and valuable is because of the very fact that they're brought quite largely by self-represented litigants. It gives you a chance to see what the individual applicant, the person with the disability, is actually seeking in a way that maybe isn't done so easily when cases are brought by advocates and lawyers. Okay, so the first category of case, I define the first category, claims seeking transportation restructuring, as cases in which the applicant seeks change in a transportation system that goes beyond accommodating their specific disability needs. This type of change is usually prompted by the observation that the able-bodied population requires less effort to use the conventional transportation system as a tool to complete the regular activities of everyday life than a person with a disability would require to complete the same activities using specialized transit. I've observed 2 things with these cases. The first is that procedurally, the administrative adjudicators do not necessarily use their discretion as they could, despite flexibility in procedure that's often given to them through their enabling statute. So flexibility of procedure, as well as ability to use non-adversarial processes, which is often also granted to them in their legislation, and if not, understood through the flexibility that's granted at common law. So, for example, in one case, a self-represented applicant asked to have the Human Rights Tribunal order the municipality to create an intermunicipal transit system. She formulated this request because she did not meet the criteria of the specialized transit system that already existed, even though she was a person with a disability. She was a self-represented litigant, and it was not clear from the record whether she sought to have the eligibility criteria for the specialized transit modified so that she could use it too. Yet the tribunal did not put this question to her squarely, so it's just kind of left, part of what I call lost discourse. So that's on a procedural level. On a substantive level, the use of the reasonable accommodation doctrine, which is quite central to equality law, limits what may be achieved in terms of equal transportation services. The challenge of using a reasonable accommodation lens, though technically it is the correct doctrinal legal lens to use, is that by nature it's a tool that allows the possibility for lesser substitutes to be provided so long as they seem, quote, reasonable. It doesn't get at, as Day and Brodsky state, the heart of the equality issue. It doesn't get to the goal of transformation, and there's no attempt to abandon the idea of normal and to look for genuine inclusiveness. So that's the first category of claim. The second category of claim found in the period examined consists of cases in which the applicant seeks access to transportation in support of a broader family dynamic. And there are many situations in which persons with disabilities require transportation for reasons other than the basic need to travel from point A to point B. For example, parents with disabilities may require transportation for their children to attend school, to get to caregivers or extracurricular activities, and generally may require transportation in order to assist with family management. These cases are not numerous in the second category, but show reluctance to interpret doctrines in a way that offers support to parents with disabilities. And one wonders if this trend will reverse in light of the ratification of the CRPD in Canada, which has an article dedicated to supporting parents with disabilities. The third category of claim consists of cases in which the complaint is prompted by a conflict or incident that occurred while the person with a disability was using the transportation system. And what I've observed within this category of case is that there are a variety of techniques that allow the tribunal to simply avoid engaging with the issues. So a number of the cases of transportation conflict are dismissed at the preliminary stage, often for being deemed by the tribunal to have no prospect of success. And I would say this has occurred most often in British Columbia. Some cases are decided on the narrowest possible issue, so that there's no real obvious example or precedent of how the tribunal would deal with a specific matter. In other words, I would say that this area shows quite vividly how the problem of narrow legal interpretation and narrow use of discretion can lead to a lack of engagement by the tribunal and to lost discourse on the part of the complainant. So the final thing that I want to do is to look at how equality theory can connect with what I've seen on the ground through these cases. So how might prevailing theories of equality correspond to the claims of applicants in the three categories of transportation equality cases that I've discussed? What are applicants seeking to obtain through their claims? I argue that the claims made within the three categories of case are first and foremost inspired by the social model of disability. The claims made in these categories also seek to align themselves with the goals of the two traditional Western theories of equality: distribution-based equality, which is a form of justice that's preoccupied with ensuring socioeconomic resources and access to them are fairly distributed, and recognition-based equality, which deals with ensuring the authentic recognition of another. In the field of political theory, authors such as Fraser, Honneth, and Taylor have debated this, arguing that misrecognition finds its source in social patterns of misrepresentation, misinterpretation, and miscommunication. But beyond these two traditional visions of equality, one can see that the claimants seek something more. They seek an acknowledgement of how commonplace a variety of life experiences are or may be, and how these life experiences may be a particular challenge to achieve if they're positive, or may have a disproportionate negative impact for individuals with disabilities if they're negative. And I call this additional aspect the universality of the human condition. The idea behind the universality of the human condition is to bring attention to experiences that we may share through life as human beings. Some of these things we've seen throughout the course of the day have been discussed, such as raising children, the possibility of being assaulted, the need to get to medical appointments and organize one's time in an efficient manner. And to have these commonplace experiences acknowledged within the legal analysis, and that's the goal of, especially the discrimination analysis, that's the goal of having the universality of the human condition. So I'm going to stop there. I'm going to stop there and just say, so thank you. That's my analysis of the transportation cases at the Human Rights Tribunal in Canada.
And Stephen.
That's not working. Yes, hello. Who knew there was Canadian studies at Cal, and it took a Canadian to organize this conference. I'm sorry if I'm going to embarrass you again, Laverne, but you really, this isn't being recorded, right? Because this school does not do enough on this subject. So thank you. I knew of Thomas Barnes when he taught here. Thomas Barnes, the person, but now there's a center named after him, and now we have a new Canadian dean, Sujit Chaudhry. They even serve Molson's beer and a maple leaf emblazoned sheet cake on a Canadian Thanksgiving Day. But I have to set the precedent established by Irene Blumerud this morning. So, chers messieurs, mesdames, chers confrères, consoeurs et honorables invités, j'essaie dans mon accent québécois ou franco-canadien, le meilleur, je vous remercie de votre participation à la fin de l'après-midi. Je disais à mes collègues qu'il faut tous faire nos présentations en français, mais we can't all do that. So I'm going to do this in English. But the ambassador would probably be okay about that tokenism there. Now, like Alok, I probably will also be a downer, I have to warn you, but more likely provocative. And that's because I'm going to be skeptical of lawyers, like Carrie. I'm not going to privilege the voice of people with disabilities necessarily. Sorry, Laverne. But look maybe to mitigate it in certain circumstances, and I'm not even going to champion due process or a rights-based approach. Now, this comes from the father of a young man who had very significant intellectual and physical disabilities and many years of practice in special ed advocacy. But the theme of this conference, Law, Disability, and Equality, gave me an opportunity to think differently about this subject, and namely equality in the educational environment. It's something I've thought about for a while, but now with a Canadian twist. Canadian models such as the Ontario Special Education Tribunal, the inquisitorial model, and that's not what you think, and also maybe looking a little bit at Quebec, and that's where the term in the title, les enfants en difficulté, is what they call kids with difficulties, is one term that's used, at least in Quebec, for children with disabilities. So trying to kind of use this as an opportunity to think about that, and again, I'm indebted to Laverne for a very comprehensive work she and colleagues did on the area of administrative law, drawing heavily on Canadian and other Anglo-American systems. And the question is there an easier way to resolve the disputes between families, parents, guardians, caretakers, and schools, administrators, teachers, specialists, therapists, service providers? That is, an alternative to the elaborate administrative agency hearing under the IDEA, the Individuals with Disabilities Education Act. I'd like to see the personnel and financial resources devoted to the educational enterprise itself. Now, I know this is the rhetoric of many, but I truly mean it. And meaningful consultation and dialogue between school and family instead of what so often ends up in conflict and frustration and anger. And Carrie talked about that. I know about that, my own experience. And I'm going to apologize to Mark Weber, who recently defended so ardently, as the Supreme Court would want ardor, the due process model. I'm using this as an opportunity to critique and welcome the criticisms. And I also want to acknowledge Jim Rosenfeld, who is the founder of COPA, the Council of Parent Attorneys and Advocates, the premier plaintiffs, students' bar, if you will, who's actually proposed something called the arbitration model. I could go on the language issue. I have special education in quotes because it's just education, right? It's not special education, and there's a lot of objection to that patronizing term. Even from a legal standpoint, it's very unsatisfying that both the IDEA and the regulations define special education as specially designed instruction to meet the unique needs of a child with a disability. And in keeping with the tautological nature of the definition, before the term was even defined in regs, the Federal Office of Special Ed Programs explained that, quote, specially designed instruction, close quote, means education planned for a particular individual or individualized instruction. Well, this is like saying the definition of special education is special education, or more precisely, specialized education. But language becomes an issue there. Inquisitorial, no, it's not about being stretched on the rack. It's a Canadian process, and it's used, again, in a lot of Anglo-American systems, mainly Anglo, New Zealand, Australia, and the UK, and I looked at some of those models. In the socio-legal context, what I'm talking about is favoring bureaucratic legalism as opposed to adversarial legalism. Now, whether the criticisms of special ed due process hearings are based on hard data or perceptions, and that's the big question, the fact remains that a rights-based adversarial appeal, even when a decision is issued within a specified time frame, it still can be a contentious, time-consuming, and or expensive process. Now, in addition, the administrative hearing process is typically, I'll explain, the process is typically not conducive to developing or maintaining a respectful and productive relationship between family and school. And so I'm recommending a new procedure for resolving disputes over the proper program and services, ones that's determined by best educational practices rather than due process of law or the assertion of rights. And in addition, the review should not be grounded in adversarial hearing, but in an inquisitorial, or in more friendly terms, active adjudication procedure. And this recommended reform is based on two key principles. First, a belief in professional judgment as the overriding factor in any kind of educational planning and execution. And in determining a student's individualized ed program, the most important voice should be that of a knowledgeable and experienced educator. Sorry if there's slings and arrows coming this way. The observations, the learning objectives, and the objections offered by the parent or other caretaker, or the student herself, if she's able, of course, should be heard and should be the next most important voice in the IEP process. Now, Carrie spoke, and her article is wonderful. Her paper is wonderful. I know it'll be a wonderful article. Talked about the understanding that parental angst, the advocacy fatigue. Although I think I talked about it with cookies and not with a cocktail group in my day. But
Cookies and cocktails.
cookies and cocktails.
We roast
Okay.
marshmallows and drink bourbon.
Okay. Yeah, and my partner and I went through many years of therapeutic play groups with wheat coffee and sandwich cream cookies. But there's when there's
You're not doing it right.
okay, and if there's no agreement at the IEP table, and that happens a lot, right? A lot of you know that. I think the review, the oversight, the appeal, whatever you want to call it, should be cloaked less in due process than in quality assurance as administered by a core of educational specialists rather than jurists. See, I'm down to the judges too, okay? And finally, I'm inspired by this inquisitorial model because it does put more control in the hands of what I'll call special master. I'll say a little bit more about that in a bit. I mean, the current process has been described as unduly expensive for parents and school districts alike, not accessible to many parents due to the cost, unavailability of attorney representation, not to mention what you talked about, Carrie, in terms of language issues, formal education, and you talked about college-educated parents and very informed and very knowledgeable still having a hard time in the process. It's particularly difficult for the so-called unrich families to bear the burden of proof, and the burden of proof now does become that of the movement, a burden of proof of the IDA's requirements, and obtaining attorneys, expert witnesses who are not compensated. There's no compensation for that if you lose. Generating a track record of success in a private placement is a more complex issue. Now, it's easy to dismiss this criticism of procedural safeguards as rhetoric from harried or hostile school administrators or the rehashed dogma of anti-government conservatives, and I know there's very few of those alive and well right now, but it must be acknowledged that the procedures have at times been adhered to in a very pro forma or even burdensome manner with no corresponding positive effect on a child's educational objectives or the family's objectives, school program, or learning outcomes. And moreover, there's been much rancor in the school conference rooms and administrative offices, not to mention the federal courthouses. And despite the congressional intent that parents and school officials form a partnership, it is not at all unusual or unexpected that parents become the adversary of the district, sometimes to the point of irreconcilable differences. I could say more about the legalized process. One of my differences with and I know not everyone agrees on this, is I think unlike the ADA, which obviously and Section 504 are very important and must be adhered to, and yes, Lainey, where'd Lainey go? Even if one needs to sue for that, okay, Mark? Yes, but unlike that, I think IDEA is not strictly speaking a civil rights statute. It is not primarily addressing discrimination, but rather educational deficits. It's defined by remediation, intervention, support, services, specialized instruction, what we might facetiously call unreasonable accommodations, or the better expression is accommodations or resources that exceed reasonable cost. And yet, a district's resistance to remediating or otherwise addressing an IDEA student's disability is often all about money and resources, and sometimes pedagogical differences. Now, while the IDEA is one of the best educational initiatives ever hatched by Congress, it's got a catchy acronym, and an improved and reborn statute, because now it's the improved, right, is the Individuals with Improved Individuals with Education Disability Act, okay, because Congress said so, it's improved, okay, reborn. And it still, I believe, needs to be reviewed as remedial, not rights-based. As I say, there's protections under the 504, and we've got ADA. There's a number of other criticisms of the process and the length of time between filing and decision, irrespective of the deadlines that are set out in the statute and regulations. It still can take a long time to get from filing to a decision, and not to mention the interim cost and process of the hearing. So I'm talking in the end about privileging professional judgment. Now, in most transactions with providers of goods and services, we give deference to the professionals, be it healthcare, construction, utilities, purchase of equipment and large appliances, nutrition, legal advice. We want candor. We want informed decision-making and communication in a language we can understand. And we like to have quality treatment or service. So why should educational services be any different? There's no reason to think that a parent knows more than a teacher or specialist about educating a child, nor should they try to. And that's what I heard Carrie talk about, and I've written about that myself. What a parent does know and excels at is observations, dreams, desires, things that happen at home, out of school, can be monitoring the process. But again, whether it's a child with a disability or a child without a disability, unless the parent has equivalent or superior knowledge or experience, I think their voice is secondary. And there's no reason to mistrust the educational professional unless, no tomatoes yet, left over from lunch, unless there is a suspicion of incompetence, negative attitude, inattentiveness, inappropriate behavior, and or poor judgment, and sometimes all rolled into one. And these too can be offset in other ways. Now, as with all professional relationships, we expect to be adequately informed, we, the parents, the caregivers, the family, the young person with a disability, if they're in a position to advocate for themselves, before giving consent to a particular educational intervention or service, and to be respected, and heard on matters in which our observations or opinions may be relevant. Now, this notion of professional judgment and the deference to that is not new. Romeo versus Youngbert, I love the name of that case, Romeo, held that courts must show deference to the judgment exercised by a qualified professional. Now, again, the context is very different. I understand that in an institutionalized setting, minimum standards, but nonetheless, that principle is there of deference to their judgment in determining the training or treatment due an individual with disabilities. And if this decision is made by a professional, it's presumptively valid. Michael Perlin argues that the professional judgment standard sharply limits the need to inquire into the adequacy of a person's treatment, close quote. Now, this is not to suggest wholesale deference, okay? And Susan Stephan has written extensively and very eloquently and knowledgeably on this subject. And yes, we just don't take all the word as gospel or the Hebrew Bible. But due process hearings are not conducive to preserving long-term relations. It may be naive on my part to seek a change in the school culture where the family and educational authorities will engage in dialogue more than argument, in collaboration more than confrontation, but it's a vision that actually matches that of the school administrator petitioners in Goss versus Lopez. Now, they weren't the winners in that case. The Supreme Court's landmark case on school suspensions. These the petitioners there conceived of the school as a community or a family of shared interess. And Martha Minow has described this, a conception whose defenders fear the, quote, continuing relationships among people with shared interests would be frustrated by the formality and distance imposed by legal procedures, that is, by rights, close quote. I'm not saying that Minow subscribed to that. She's defined it well in ways that the decision does not say in its own terms. And now, while this conception was not adopted by the court majority, was not adopted by the court majority, just 5 minutes encore, okay? The dissent embraced it and referred to the student-teacher relationship as one that is rarely adversary in nature and, quote, in which the teacher must occupy many roles, educator, advisor, friend, and at times parent substitute. Now, maybe that's leave it to beaver type stuff. I don't know, but I kind of think that's an image I'd like to see return to the school. And I think the non-adversarial model brings that. And let me tell you just about what a few of those elements of the administrative review would involve. And again, I call it an administrative review. Were you able to hear me now that I'm close to the mic? Is that better? It's not necessarily a hearing. It's a process that should contain certain elements, and I'm still working this out, and it should be reviewed by someone. I welcome thoughts on the term. I'm saying special master, who's an experienced special educator or special ed academic, someone who's spent a long time in the schools, in the educational establishment, the teacher training schools in California. That would be the Cal State U, for instance. A lot of very progressive educators and folks knowledgeable in pedagogy. Not a lawyer or a jurist. And some of this, by the way, happens in some states. We do have in the hearing process already special educators, and then even the Ontario Tribunal does use some some educators more than jurists in some cases, but the jurists dominate. And here again, I would dismiss the jurists, the judges, for reasons other than you described, Carrie. But it's about obtaining early disclosure to the special master, including areas to be covered, witnesses to be called, a master-led focusing of the issues for determination, using the information supplied by the parties, which is often going to be sending up some of the records, the IP documents, not, where was it, Elizabeth had that pile of documents before. I know some people love having IPs that look like that, but something a little more, a little slimmed down, maybe even done by internet, and that the parties can supply it. That person's going to rely on her own expertise. The master is going to facilitate the eliciting of evidence, no new documents unless requested by the special master or not available at the time of the IEP meeting or resolution conference, and that's a key core of our legal principles on appeal. Master can engage in independent fact-finding, request additional information, call witnesses on her own motion, may take notice of any judicially noticed facts and opinions or within her specialized knowledge, quote unquote. Less emphasis on single determinative hearing with oral arguments, but rather written submissions being more frequent than oral. Word counts, of course. Master adapting to the needs of the parties to ensure meaningful access. No cross-examination, just questions by the master himself. And allowing an advisor in lieu of an attorney. And I haven't thought that through entirely, but there are procedures, including this university, not to its credit, but in some disciplinary hearings here, I don't advise this in all instances, there's the absence of legal representation, but a support person. And again, I look to the Ontario model where a person can come and be there as supportive and not necessarily in the role of attorney, but be present. Based on the record below, as I say, IEPs, evaluations, and so forth. No oral argument unless requested by the special master, and no new witnesses. I still favor robust IEPs, not marathon, I said, but robust, okay? I've had colleagues who love that they were at 2-day IEPs, not really interested in that. Facilitated IEPs, which is now some couple, I don't know, 15 years old, is a great model. Take the administrators out of the process. How am I doing? Another 2 minutes? Do I have 1 minute? Yikes.
1 minute.
Okay, got it. Thank you, Leila. Mediation. I'm a big proponent of mediation. So all that can still happen with this model, and that's really where it should be. But if that fails, I would see this inquisitorial model. Obviously, there's objections about fairness, disincentives to resolve the dispute at the school district level. I still would see a judicial appeal, and looking at either American standards of review on administrative, such as de novo of the special master's decision. Was it clearly erroneous? Was it supported by substantial evidence? Haven't thought all that through. That's the most deferential, the last one. Canada uses standards such as correctness or reasonableness, which is more deferential, of the master's decision again. And I'd like in the end to see these funds redirected from lawyers and administrators to evidence-based researchers and school district or consortium specialists. Now, I know this isn't going to go dollar for dollar, transferring of funds from litigation or from the liability insurance premiums, but I think those funds we can save can be used for better teacher training. I forgot who this morning spoke about teacher training, how we get what teachers get 5 minutes worth, basically. Oh, speaking of time, they get 5 minutes worth of education. We can do a much better job in terms of training highly educated teachers at the academy, at the university before they leave and go into the schoolhouse. And anyway, I'll save other comments for later. Thank you. Merci.
What an amazing collection of papers. Can you guys hear me okay? All right. Thank you to all of our presenters. I'm going to take about 5 to 7 minutes for comments. I'm going to pull out some ideas, some themes and threads, and then I'll be opening up to questions. I know there'll be questions. I'm going to frame my comments with 2 ideas from 2 amazing disability studies scholars to begin. The first from Arlene Cantor. To the extent that law is generally viewed as a system of rules that shape politics, power, and society, it becomes the vehicle with which the status quo and existing power relationships are maintained. And from David Pfeiffer, speaking right after passage of the ADA, if people with disabilities have the right to exist in this society, then they have the right to ways that make the existence meaningful and effective. What strikes me about the writing of our panelists today is that even where they may reach different conclusions regarding the best hack, if you will, for a given set of processes and procedures, their work states unequivocally that the system of rules, the administrative processes, these are the spaces where citizens with disabilities and society are interacting. They shape society and they maintain existing power relationships, and they must be challenged and reworked in this era so that they are a way that helps effect the meaningful existence of people with disabilities in our society. At the end of the day, they're asking us to consider if the processes and procedures that theoretically exist to facilitate an individual enforcing rights under law are in fact acting themselves to enforce a healthy or an unhealthy relationship. Are they being utilized to maintain a status quo that is just, or is it unjust? Are they a force that is empowering or oppressive in and of themselves? Ultimately, how can they be revisioned to support effective and meaningful participation in society by all for the benefit of all? Inquisition was a theme to me in all of the first three, the last three papers, and I do apologize I didn't have Professor Chatterjee's paper ahead of time. I'll weave it in as is possible. Steve, you sought to import from Canada to rearrange the power dynamics, this model of inquisition in educational proceedings, adding a third empowered party to inquire. Laverne, looking at transportation law cases, you want the bench in Canada to engage that in a meaningful way, to actually seek the universal humanity, to find with claimants a true story of what is sought, really making into a mutual experience the dynamic posited by narrative theory, where we're told as advocates to tell stories to people in power and the public in which they can find universal truths and engage with us in our struggle. Carrie, you discussed creating a framework for discussion in educational settings that would include a set of inquiries requisite in these interactions that bring both sides of the experience in for consideration and include both sides for inquisition. No small feat where it is marginalized families that are part of a pairing with a large system. Each of you is thinking, secondly, I found that each of you is thinking, and this is for all the panelists, in very different ways on your topic from both thinkers before you and those around you generally in academy. Steve, you say right out in your paper that you reject the label of heretic for thinking that pedagogy could take precedence over law. Laverne,
I didn't say I reject the label. I said I fear it.
I take it as a stronger statement. You reject it. Go with that. Okay. Laverne, you turn away from any of the negative connotations that might flow from vulnerabilities theory. And Carrie, you interrogate the focus on the gaze of those with, quote, the biggest platform to speak as the only worthwhile gaze to consider in education and educational conflict between families and systems. Such departure is rare when things are progressing well. And Alok, you stated you were uncomfortable with the sort of fetishization of class action. Are we in an era of disenchantment as the movement reaches middle age, or are we just drilling down on a larger perspective, with a larger perspective, on some of the lasting and really difficult barriers to break? It seems that we are, whether we're discussing human rights tribunals, grand jury proceedings, administrative trials in education, or class action certification processes. Today, where once the interrogation of the state was, are there rights? And are the laws about them correct? Are they just? It has become a dialectic about, is the process and procedure just, with justice necessarily implicating efficacy? There seems to be an anxiety that the explicit status bias of the system has been replaced with an implicit bias that seeks to protect the fisc of the state and limit its obligations to its citizens in the process. And finally, this brings me to a third thread. Economics, not classic cost benefit of independent living versus institutions, or special education will save us money later. But at an era when we have, it seems, both in Canada and the US, no intention of paying the higher cost later for not educating you now, but instead will simply incarcerate you and allow private corporations to make money from you. When we have no intention for paying for expensive institutions, we're just deciding that we will allow the investing class to house you for profit, even if it's in nursing homes, even if it violates the spirit and the letter of Olmsted. The things we want, wins on transportation, educational processes that result in solid best practice services, all require not law but appropriation now, and at a time when there seems to be little chance of a revival in Canada or the US of progressive economic nationalism, ruled out by anything like a strong middle class or activist politicians with which to ally. How do we move these concerns? How do we move the dollar bottom line? I have a few things that I'm going to bring up, but I want to make sure I'm not going over into other people's questions. I love the term unrich. Stephen, can I just say that? That's wonderful. The rich and the unrich, and why it is that all of you are talking about the problems with lack of representation for the unrich, meaning most of us. I'm interested in issues of, with a special master, appointed styled individual, whether or not with school systems that are continually engaging and families just passing through, would there be problems with enmeshment there? Laverne, your cases, I felt they were so compelling. I felt so sorry for the litigants that made it so far in the Human Rights Tribunal, to be handled so pedantically. really, by the court, seeming to act so conservatively in treatment, really looking as though it was aiming to achieve a desired end of reinforcing existing status quo. And Carrie, for you, I was wondering, it looked like the idea of a parent collaboration or a parent consortium to address the voicelessness of parents in collaborations with schools and do policy sharing and governance sharing. It reminded me a great deal of the parent policy councils in Head Start, which really were put into place recognizing that poor African American parents, largely in the South, would tend to not have their voices heard and their experiences recognized and their wisdom taken by the system in which their children were participating. And Alok, I was really interested, I was very interested to hear you talk about the class action and your discomfort with how it was presented as sort of a hero story of, oh, look, everything's solved now, everything's wonderful. And it was almost the opposite of sort of what we talk about like poverty porn, of sending out, pictures of marginalized people just immiserated in order to try to get money to fix immiseration. And how does reinforcing those stereotypes within a legal milieu pour over and undermine us in the larger societal context? So those are my comments, my reflections, and I just want to thank you all again so much and open it up to questions from the audience or from panelists to one another, since much of your work was intertwined.
So if I can ask this question myself, just a second. So between Alok and Laverne, I was wondering about, were there any class actions that you know about regarding transportation? And how does that fall out? I know where I'm from, there were some, and they were very successful. And I'm just curious about that.
I think... am I speaking the right direction? I'm not very good with microphones. I think if we were to take if we don't take if we don't, at least speaking in Canada, if we don't take a purist conception of what exactly counts as a class proceeding under the particular legislation, and if we include other forms of representative actions and aggregations, there is one win in the sense that it resulted in a sort of a positive remedy that benefited all persons who faced discrimination. That was the fact that Via Rail, which is a Crown corporation in Canada that provides train service to unfortunately increasingly smaller parts of the country, the fact that they bought railway cars that were inaccessible. In fact, my understanding is that they were able to get them on the cheap because they were not suitable in other jurisdictions. And so, but in that case, it did go to the Supreme Court, and by a 5-4 split, they were successful. But from a point of view of the importance of process enforcing and implementing disability rights, that procedure not only provides the mechanism by which the law gets implemented, but it also, in my view at least, has the potential and the tendency to structure and drive the articulation and development of the law. And in that case, I think it's really telling that I think most of the time in the lower proceedings was spent arguing about jurisdictional points. And so it's one of those cases that all the disability issues didn't really get adequately addressed where they were meant to be addressed because legal process issues sort of just made them disappear. So it's unfortunate. But it was a win.
No, I agree. I actually really appreciate Alok's way of conceiving of these cases. They're not necessarily class actions, but they're those that have a wide systemic impact. I would say that if we look at tribunals, human rights tribunals, one case that has had quite a significant impact is the Lipovsky case, or Lipovsky set of cases. They dealt with whether or not public transit was calling out the stops so that persons who were visually impaired would be able to know where they were going. That had an impact not just from the Human Rights Tribunal, but the commissions. We have human rights commissions as well that have an educational function in part. They have some other functions as well, depending on jurisdiction. But they, in Ontario, the Human Rights Commission went out and impelled other jurisdictions, other municipalities to call out the stops as well. So, similar kind of cascading of systemic impact, although not necessarily a class action.
That's not a problem in the U.S. about calling out stops. All bus drivers do. I'm just kidding.
So, I guess I'm supposed to say who I am. My name is Betsy Brazy. I'm a special education attorney in Alameda and also a parent of a child with disabilities. So, Carrie, welcome to my world. One of the things that I think really should be handed out to all parents when they end up dealing and understanding that they do have a child whose needs are not going to fit whatever normal is that we provide the parents also with psychological mental support. And I think it's kind of funny to say that there's parents who are disabled and parents who aren't, because in some way we have quite a commonality on that. So the other thing is that what we do say about this now is that once you start special ed, it's not a sprint and it's a marathon. And you're right, it is very, very exhausting. So.
Yeah, I find it very interesting that we haven't recognized the way in which we create new categories of disability, whether they're physical or mental or resource driven, based on the experience of interacting with the administrative system. I mean, education is just one example of that, but it's a very concrete one in which somebody who didn't have a disability before entering because of their affiliation with their child with a disability or their sibling with a disability, I mean, there are trickle effects, or supporting another family in their community with a disability suddenly takes on all of that, and it has real effects, and there isn't a support network, and it's so stigmatizing based on diagnosis as well, and so people don't feel like they have the space to talk about it, and it can be a really individualizing and alienating experience, which also drives down their ability to advocate, and so people stop. And it makes sense. It's self-preservation. It makes sense. Stop doing it because it's not a mental health friendly endeavor, and it's a long one. It's not fast.
Since I grabbed the microphone first, thank you all for your presentations. I did have a brief comment on Steve's, and I've gone over some of this with him already, and I think it's probably I was inspired by the fact that anybody who could be labeled a heretic probably is on somewhat shaky ground going for an inquisitorial process. You know?
Yeah, but you're the St. Vincent de Paul professor.
That's why, you know. I must say, when I came in here, I did not expect the Spanish Inquisition.
Well, you ought to be going to a Jesuit university. How about Loyola of Chicago?
I know, okay. So the comment is, though, that it does strike me that there is some real tension between what's being suggested here and what I think a lot of us think of as some fairly fundamental ideas of disability rights. For example, departing from an over-control by professionals, which, frankly, I always thought was part of the worst part of the Romeo case or the worst part of the Olmsted case. Similarly, it does strike me as fairly important that we do think of IDEA, the special education law, very much as a civil rights statute because it gives unreasonable accommodations. The big problem I see with the ADA and with the general civil rights approach is that you kind of stop when it's no longer reasonable, which is, of course, using the non-disabled person as the norm, and it's not actually creating functional equality, which you would have if you went beyond that. Interestingly, IDEA actually does go beyond that, and so for that reason is a civil rights statute, in addition to the fact that the main reason it was passed was because of all of these civil rights lawsuits. So I think there are some concerns there, and if I could just advance the discussion by suggesting that, I would.
Well, yeah, and Mark, by no means am I saying get rid of the unreasonable accommodations. I think they're necessary. I'm not talking about the standards. I'm talking about how you realize them. And also, you know, we could quibble over whether it's a civil rights statute or not. I'm just saying I look at it mainly as about interventions and strategies and remediation and so forth, and the focus there. That's why I do defer to the professional judgment, and again, not unhindered. but with good reasons to thwart that judgment, to challenge it when one can, but otherwise to go with the presumption. And there's other checks and balances in the system throughout, including, as I say, below the administrative review level. Lots of opportunities, and I think most people would agree that even if you kept the due process model, that things are always better resolved at the mediation level.
One thing I thought was interesting, I'm looking forward to reading your paper on the plane home, but one thing the first distinction that I thought of, because you made me really uneasy as a parent. I'm like, wait, I do know better than lots of people. I'm pretty confident in that right now, after coming out of my IEP meeting on Wednesday. But there are other things where I'm like, yeah, you do know. But when you were giving examples of like carpenters and architects and doctors and accountants, if I don't like what they have to say, I have the option of shopping around, because I wouldn't just stop there, because I often have to do that with my own medical care, for example. I mean, that's just not truth to me. So you find the right match, and I think that that's the difficulty in the system. You don't get to pick your match. And with a special master, you might be stuck with that match, since the higher privileging of expert knowledge, and there isn't that flexibility. I mean, I realize you could invoke other procedural protections, but the shopping around is a really important distinction, at least in my mind.
Yeah, and I think the second opinion can come in many ways. Again, at the IEP level, one can request an independent evaluation. Also, the special master can herself say, I want to hear from someone else. And of course, you need the neutrality of that person in addition to their experience. So that, because a lot of times people feel the admin law judge is a captive of the school districts or the state department of ed, the state ed agency. So I recognize that. And again, I think what Mark is saying also, on the point about needing that some aspect of that adversarial process, but so I don't think it's impossible to have a second opinion.
Okay, hi, I'm Ravi Malhotra. I just have a very technical and quick question. Thank you to all the presenters. This is a great panel, but my question is solely for Laverne. I was wondering if you had looked, coming from Ottawa, I'm curious if you'd looked at any of the federal cases, if you looked at the federal tribunal, because as someone who teaches admin law but only has a skeletal understanding of the course, I often get lost in this concurrent jurisdiction between the CTA and the federal, and the federal rule seems different. So I was just curious if you'd comment on federal transportation cases.
Yeah. Yes, absolutely. And I actually did exclude the CTA cases. So the CTA takes matters that deal with federal interjurisdictional transportation, so rail, air travel, etc. What happens under the Canadian Transportation Act is that there is exclusive jurisdiction given to the CTA to handle disability matters. So it becomes rather complex. We've had some cases, such as the Morton case, where the applicant has tried to go to the Human Rights Tribunal or Commission afterwards to see whether or not they can have discrimination determined. And that's been struck down by the federal court, saying clearly that if you read the Canadian Transportation Act, it was meant, and actually if you read the Via Rail case as well, it was clear that both the statute and the Supreme Court have determined that the place, the jurisdictional place for these questions is the transportation agency. So we have a challenge. If you look through the reason I excluded the CTA cases is because I wanted to focus in part on matters that are daily activities of persons with disabilities. And I didn't feel that rail and air actually fit in very well. But if you look at the decisions coming out of the CTA cases, there is, I would say some questionable interpretations of human rights matters. And so I think it's something that definitely should be revisited, and I think it deserves its own, paper analysis of its own. So thanks.
Hi, Arlene Cantor, Syracuse University. Fabulous panel, as was the last one. This has been really a spectacular day. I have a point addressed to Carrie and to Stephen. This whole idea of getting away from litigation in education cases, I think, is really important. So one question I'll ask, I have four little parts, is what's happening in Canada for kids with disabilities and access to public education, and what follow-up from the Moore case, which I referenced earlier. Second, at Syracuse, I decided, I've been involved in a lot of these special ed cases that did not end up well in terms of the relationship between the parents and the school. We started something called SUPAC, Syracuse University Parent Advocacy Center, in which the goal is to educate parents about their rights so they can be their self-advocates, and to partner with graduate students and law students to accompany them to IDEA hearings in a non-adversarial way. The law students do not identify that they're law students, they identify they're Syracuse University students. It's been very successful. However, it only goes so far because the school districts know damn well that they can be sued and that they don't really have to do anything. And if the parents really want something, the parents will sue them. So my question is, given the fact that we live in the world of litigation and IDEA cases, how do we move from that current world to something that can be more ameliorative? The third related question is what my students ask me all the time, which is if we want to try to reduce litigation in IDEA, develop more equitable schools, in fact, inclusive education, which means that all teachers have to teach all students, then why would we have these special processes for kids with disabilities? Why aren't we why aren't we developing ways and advocacy tools to educate all better? And maybe that's a separate conference, but sorry, those are my questions.
Oh, yeah, I'm going to defer to Canada to Laverne on that one. Yeah. And I think Carrie will too.
That sounds good.
You're living closer to the border these days. No, on your a couple things on your. I couldn't tell if there were 3 points there or 4, Arlene. But I've long advocated that every student should have an IEP. Okay, I've said ILP. Okay, give it any acronym you want. Individuated instruction. It's talked about a lot. I think again, it's more rhetoric than reality. But it's a great idea. And again, I go back to the point, and I've heard this from folks in the field, if the teachers had more than 5 minutes of special ed instruction when they're in teacher training. I mean, law students, we get a core curriculum the first year. We don't get to decide what we're taking. Why isn't every teacher offered a substantial number of courses in special ed so they are able, or individuated instruction, so they're able to function in any educational environment? As to the SUPACs, see, I think one of the problems with, I'm all for parent training, and again, that should definitely happen, and your clinic is fantastic at Syracuse. I mean, your whole program, you're like the only law school in the country with a really disability-focused, here I go again putting down this place, for a disability-focused law school curriculum, and your clinic in particular, and there are a number of special ed clinics. I think it's a great learning model for students in the clinical setting. But I think so often the parent training is about mastering the regs and the law and not about negotiation, having those skills, getting the second opinions, doing what it takes to kind of work collaboratively and to challenge. It focuses so much on the legal process. So the training, I think, is sometimes problematic in that respect. And I think Carrie and then Laverne want to talk about Canada.
Oh, it doesn't matter.
Well, I was going to say that with respect to the question of what's going on in Canada, it's really interesting. I know that there are very few special education tribunals in Canada. Ontario has one. I think there's one in British Columbia. And the very interesting phenomenon that's actually happened on the ground of late in Ontario is that the special education cases are being heard by human rights tribunals now. So, yeah, and I think part of the motivation for doing that was to make sure that there is some sort of, human rights social model approach to these matters. So that's one thing that I would say about what's going on in Canada. And I think Alok has something to say too.
Hi. I think in Canada there's also a very diverse approach when it comes to these issues. When I was on the commission, I think around the time we were finalizing, under the legislation that exists in the province where I live, the commission has the ability to issue something called guidelines. And guidelines are not exact, there's something less than regulations, but they have binding nature. So a lot of it depends on getting the wording in the guidelines with enough flexibility, but enough concrete suggestions. And I think that's a big development. And I think someone should look at the guideline making process that's happening in the jurisdictions with that. But I just wanted to also say about this Moore case that came out. I think that I in some ways, I'm very pleased with the decision, but I think it also has limitations. There was no remedy awarded at the end of the day. And so it was a very easy case for the court to say very nice things and lots of platitudes because the individual in question was out of the school system and wouldn't be returning there. And so, the mootness of the case made it easy. And that's sort of in Canada, it's possible for cases that are moot to be heard. And so in many cases, the courts have said very positive things where the issue is technically moot, but unfortunately, in cases where there are actually live controversies, that hasn't really translated into as much positive things. So I think you have to read more with the understanding that there was no remedy at the end of the day, and I think that certainly has a hue on the rest of the decision.
Carrie, do you want to respond to that? And then after that, I'm just going to have to say that the break was supposed to begin at 3, so I don't want to go into the next panel. You guys have wonderful questions, but after Carrie's response, I just remind you that you need to come back at 3:15 for the fourth and final panel of the day, Current Disability Rights Litigation in California, with disability rights advocates Haben Girma and Disability Rights Education Defense Fund's Arlene Meyerson, facilitated by Keith Hyatt. So Carrie, you want to close us out?
I'll be super quick about that. So what I understand from the education literature is that even when parents go through mediation over disputes in education, even if they may win, they don't feel like the quality of their relationship with the schools has improved. In fact, the language is they have fewer negative interactions, not that they have more positive interactions. And you're like, are we splitting hairs there? And I think this is a question of values and how we perceive the lives of people with disabilities and therefore their families of people with disabilities, they themselves may have disabilities or other marginalized communities. And so I think that it's not only having more in the way of education in ed leadership and teacher training programs around disability and other marginalized experiences, it's the content. So I, for example, started out taking some school counseling classes in which our special ed textbook was organized by disability diagnosis. We did a different one every week. At some point I was like, I am going to kill someone because this is just wrong. And I ended up teaching the class in the end because of this is not how we approach special ed. Let me find you in your book with the what if you have 2 of them? You have 2 chapters that apply to you. So I just think that is really missing. And maybe it's vibrant in places like Syracuse, but it's really missing in what we see in the content. So you have a disconnect in values and you have protracted conflict. So finding a way pragmatically to shorten that conflict and get people more on the page of asking about their gaps in knowledge, that requires hiring and supporting a more diverse teaching and school leadership, staff everywhere, encouraging people with disabilities to go into teaching, to be principals, to be superintendents, to be more than gatekeepers and faces of disability. And I think that's really key as well.
Thank you. Feel free to stalk the panelists as they look for the bathrooms. And you have a beautiful shirt. I love that. It's gorgeous. How are you? Haven't seen you in a long time. I know.
And then we never ended up
I know. Because we're busy and have lives and stuff. I know,
We
right?
have lunch every day.
That's right. And it just doesn't happen. Even once a week. Even once a year.
So we have lunch. Having a disability and know what that means. And one day reasonable accommodation. That's not from the perspective of the person with the disability, right?
I want to show you your PowerPoint. Your PowerPoint, I save it to here. Right? You are the last person to do the speech. So I will set it up for you and then
Do we have to have a thing on the side? Oh, okay.
Yeah, right.
And then what do I press when I want to change?
Where is my clicker? No.
I can stand up here.
Oh, okay. I can give you a clicker. This one is very convenient, so you can just hold it and then press that one is forward, backward.
Okay.
Let's try it.
Perfect.
Let's try it one time so you know how to do it.
Perfect.
Yeah.
Thank
Okay.
you.
Thanks. So maybe Keith, let's see, and the next person will be him. I think he goes first.
I'm going first, I think.
You go first?
Yeah.
Okay, sure.
Where is she?
Oh.
Haven.
Okay, so I will let you go first.
hi.
So I will turn your PowerPoint.
I think I'm supposed to go first, yeah.
Okay.
Where is she, though?
I don't know.
Haven, I don't see
Are
her.
you studying here or are you working?
Where is Keith?
Oh, okay.
Oh, there he is. Did you see Haven? Have you seen Haven? I don't think she's here.
Oh, really?
Okay. Some would say that too about law, but anyway.
Some premise attached to it. You actually read the case, it doesn't really say.
Yeah.
And I was wondering, with the class action decision that's presented as this triumph, can it, I mean, despite your first 2 points, can we assume that role and play that role of being like,
When there has been published, when there sorry, it's getting loud. The only thing is that in other cases, right, the class actions have failed. The majority fail. It's only the exceptional cases that make it as far. So that's why I think it's a bit limited. Do you know what I mean? Like, so there's other cases where the claimants haven't even gotten out the door, and the defendant has them dismissed at the certification stage. Do you know what I mean? So I think. And so no matter what's said in those cases, the only reason why they weren't able to get dismissed was because the claimants had access to all of that.
They were lucky.
They were lucky. They were lucky, and it was, and they were, and the hard work wasn't done by the court being particularly progressive, right? Or being particularly good when it comes to disabilities. It just so happens that they couldn't, if I would say this, they couldn't behave in an able-bodied fashion because of all the information that had been disclosed in the public inquiry. Do you know what I mean? They were not going to say the public inquiry got it wrong.
Right. Yeah.
So it would have been too hard. So whereas if they did have that information, they could have used their own experience and biases, and they would have. I think they might not have reached the same. In fact, I know they wouldn't have reached the same result.
Is there an alternative?
What?
Granted that the class action.
See, that's why I think.
Class action rule is not.
See, this is why I think the test case is a better strategy. I think it's better for public interest groups to find a compelling case and develop it very richly with narrative detail in a way that makes it compelling.
Right.
And I think, especially if you're having a cutting-edge case, I think the equities of the case. I think in some ways a good or a correctly chosen test case by a public interest group has more potential because they have access to a variety of cases and they can pick the best one.
Right. Yes. I mean, it's interesting. There's always the discussion here that class action rule is becoming increasingly narrow.
Yes. Yes. Narrow. Well, I think they want me to vacate the panel. Sorry, but I'll come around. Just how do I get around her?
Hello, it's Rita right next to you if you want to have a...
I have to actually retrieve my bag, which is somewhere back here.
It's a backpack with yellow things?
Yeah.
Okay.
That's great. Now I have to vacate. Which way to go? Come this way. Okay, I'll follow Laverne.
Okay. How can I greet her?
This is Rita.
Okay. No, Carly's going to sit right here. Next. Oh, you're from
Yeah. I'm good. How are you? I'm good. Yeah, I'm looking forward to your talk. Oh yeah, I saw that. Yeah, that was really good. Yeah. That's what community is.
I know, I've asked you before, and you told me
That's a community.
now I got it. If you have time, that'd be great. I understand because Yes. I got an award.
Oh, wow. Very cool.
The last conference was in at the Washington Center, and I got an award.
I was there too this summer, right?
Were you not there? Were you there for the award?
I missed part of it. My flight arrived that day, so I missed a good chunk of the opening ceremony.
Oh, okay, because I got an award with Bill Lee, who was my club counselor.
Does Bill work at DREBL or another firm?
He works at a small law firm. It's called Lewis Heinrich. And there's a lot of other names after it. No, that's another one. That is from Goldstein. That firm starts with the name Goldstein. There's another one, yeah, because there's the one in Maryland. Daniel.
Yeah, we're co-counseling for the script keys.
Are you two ready?
Yeah.
All right, I'll go ahead and get us started now, okay?
Oh wait, that goes backwards. I should go. Oh wait, where's my little? Oh.
Probably wants to be able to flick through the
Slide deck?
slides.
Yes.
How will she be able to do that?
Good question. Yes? Perfect. There's a laptop right here at the podium. I believe.
And what did he say?
Unfortunately, it's attached to the podium, but we can move her microphone and her keyboard to the podium. The microphone is wireless, and there's room on the podium for both keyboards.
Oh,
I can move to the. I can move
It's
to
just
the.
at the last slide instead of the first. Is that right? Slides are okay now?
Yeah.
Okay. Sorry about that.
Okay, everyone. We're going to start the next panel now. So if you could take your places, that would be great.
So, Laverne said she was going to call everyone to order. I think she just did that. And then I'll do a really short introduction.
Okay, you got some bio, right?
Yeah. It's short, though. They told me really short.
Okay.
And we'll leave out the multitude of accomplishments that I think everyone here knows you. You're famous. I'm kind of excited about this. All right, thank you everyone for joining us here today. Thanks for sticking around for this, the fourth and final session of this symposium, Current Disability Rights Litigation in California. Thanks everyone, if you can just take your seats and make your way back in. My name is Keith Hyatt. I'm a student here in the Jurisprudence and Social Policy doctoral program at Bolt. I want to remind you, I'm going to introduce our two panelists. I want to remind you that full bios for each panelist are available on the symposium website. Our first panelist is, let's see, I mixed up the order here. We're going to change it from the way it may be written down. But our first panelist will be Arlene Meyerson. Arlene is directing attorney at DREDF, the Disability Rights and Education Defense Fund. As directing attorney, she's led the way in what are, in my opinion, some of the most cutting-edge cases involving access to the internet-connected world. She teaches disability rights here at Berkeley Law, a class that was very influential on me years ago, and for which she won the John and Elizabeth Bolt Lecturer Award in 2013. She's also a Bolt alum and took an LLM from Georgetown University. You should know that she is also the author of a comprehensive 3-volume treatise on the ADA called Americans with Disabilities Act, Annotated Legislative History, Regulations, and Commentary, published in 1994, and it's the authoritative work on that subject. Haben Girma is a Skadden Fellow at Disability Rights Advocates. She was recognized by the White House as a champion of change last year. She's a graduate of Harvard Law, where she was involved in the Berkman Center for Internet and Society, something that's really a place that's really been foundational for my research work. She's also an accomplished dancer, from what I read on her bio. And I want to note, Haben told me that Disability Rights Advocates has internships and fellowship opportunities for interested students and recent law school graduates. So if you're interested, please check out their website or talk to Haben. Each panelist will have 20 minutes, and the presentations will be followed by a question and answer period. Immediately after this panel, there will be brief closing remarks followed by a reception across the hall in the Goldberg Room, where we had lunch at 4:30. With that, I will turn it over to Arlene.
Good afternoon, everyone. The diehards here who stayed for the whole thing. I'm going to be talking about access to the internet, and in particular, I'm going to be taking you through the story of the Netflix case, but in that story are a lot of other areas and issues and entities that would also be applicable. First of all, just laying the groundwork, there are 36 million deaf and hard of hearing Americans. So it's a very, very large amount of people, and oftentimes, you know, the people cite different amounts for how many people with disabilities in the whole country, and they 46 million, et cetera. But deaf and hard of hearing is not included in like a 46 million people estimate, because there's 36 million deaf and hard of hearing people. So the ADA was passed with the concept that there would be a national civil rights statute for people with disabilities, and there are a couple ways that it was really sold to Congress. And one was, people with disabilities are the largest minority in the country and don't have the civil rights of other minorities and women. So there was this idea that we were equalizing the civil rights of minorities and women to people with disabilities. So that was one of the big calling cards. And the other, of course, was that we were going to be using concepts that had been developed in a previous law, Section 504 of the Rehabilitation Act of 1973, concepts such as reasonable accommodation. So with that background, we, of course, as most of you know, the ADA has various titles. Title I of the ADA, which covers employment discrimination, had a very, very strong precedent in Section 504 employment regulations. Title II of the ADA, that covers public, state and local governments, is actually the same as 504, basically, of the Rehabilitation Act. So the idea of covering businesses in the community, Title III, was really the most radical of the propositions of the ADA, because there was no precedent at all. So there had never been where, just to go back a second, 504 only covered recipients of federal financial assistance. So where Title I of the ADA adopts the same rules and regulations primarily as 504, it extended it to the private sector. So it was huge. But the concepts of how, who was covered, we were really copying laws that have been regulations that have been established in 504, and those have been based on gender discrimination, employment regulations, and those have been based on race discrimination employment provisions. So there was a body of standards that were just being carried over to a much bigger group of people. Again, Title II of the ADA is pretty much the same as Section 504. Title III of the ADA, which is what we're going to be talking about today, was a brand new blank slate. So going with this concept, well, we want to have the same civil rights as other minorities and women. The first thing that, of course, was asked of us was, well, if you want to have the same civil rights, we should be, you want to add this whole new area of public accommodations, and public accommodations actually mean private businesses. It's very confusing to a lot of people. Let's look to the 1964 Civil Rights Act of Title II. And that law very specifically covers inns, hotels, motels, restaurants, cafeterias, motion picture houses, and places of entertainment. So when people were getting together to talk about the ADA and the public accommodation new title, we looked at that definition and we go, that's just not going to do. But here we are with like the banner of we want the same rights. And so there was a lot of testimony in Congress, and mainly, the idea that we ended up putting forward is you can't have it so limited, because for disability, it means you could get a pastrami sandwich, but you couldn't get your prescription. And basically the idea being that in race, and in the 1964 Civil Rights Act, there was a real focus on the areas that were the biggest problems. And for people with disabilities, accessing public accommodations, accessing businesses and services and goods that everyone else could access, the whole thing was a problem. So the very first definition in the ADA was all businesses to which the public is invited. So this did not go without attention to the White House, which at the time was supporting the passage of the ADA, but then looked at that definition and they went, well, that's just not way beyond what you said you were doing, which was making it equal to the 1964 Civil Rights Act. And we explained, well, that just wouldn't work. You could get a sandwich, but you couldn't do all these other things. And so there was this big brouhaha at the White House, a big shoot down between Sununu and Kennedy about you can't have this any place the public's invited because that's just so broad. We don't know what it is. And you can't have, and we were like, well, you can't have just inns and restaurants and movie theaters because that's just not going to do the trick at all. So there was this scramble at the White House, and really the truth of the matter is that how the compromise came about was Sununu saying, I want to know what those places are. And we're thinking, how can you know, what are we going to write, everything? And so someone came up with the great idea of taking out the yellow pages. And just looking at what are all the categories of businesses that there are. And then and that's how it happened. And we got this list of 12 types of places. And so it's basically a place of public accommodation means a facility operated by a private entity whose operations affect commerce and fall within at least one of the following categories. 12 categories, of course the ones that were in the 1964 Civil Rights Act, the first one, the inns, the motels, the places that people stay when they're traveling. The second, places where people eat. The third, a motion picture house. So that's right there. Those are the ones that were in the 1964 Civil Rights Act. Next one was an auditorium, convention center, lecture hall. The next one was and these go on, bakery, grocery store, clothing store. I mean, there's also if you look at the list, it's actually kind of funny because there's this really, really weird mix. For instance, One category is like places where you go for services. So laundromat and dry cleaner is mixed in with lawyer and doctor, because they're like services that you're going for. The important part of the definitions that we're going to be talking about that were so important in the Netflix case is that when it says motion picture, house, theater, concert hall, stadium, and then it goes, or other place of exhibition or entertainment. When it says the laundromat and your lawyer, it says, or other service establishment. When it says a park, zoo, amusement park, it says, or other place of recreation. So we decided when Netflix came into being, I don't know if any of you remember this, but it was a major splash. I mean, it was like, it took the entertainment industry by a storm and really offered something that was brand new. I mean, now we're used to it, but at the time, people were very excited about it. And this idea that you can, watch what you want, when you want, in your own home. And the problem with it when it came out was that most of the things, many things, did not have captions. So it wasn't a great new thing for deaf people. It was, in fact, another thing, a great new thing that deaf people didn't have access to. And so there was a lot of buzz. I mean, the deaf community was really on top of this Netflix thing. And they started out by asking this really simple demand, which is, can The Wizard of Oz, which was going to have its 50th anniversary, can The Wizard of Oz be captioned? And this was like, there's all this correspondence about The Wizard of Oz, and sure enough, they said, no. So that really made people mad. And then, anyway, so then there was, a lot of chatter on the internet, and they were saying, well, we have a few, and there was also no way to find out which one. So I used captions, and I would be like, oh, great, Netflix, I want to watch this. No captions. I want to watch this. No captions. I want to watch this. No captions. Because it turned out that the things that I wanted to watch weren't the most popular things because I'm not that into the Housewives of Atlanta. And actually at the time, New Jersey. So we sat down to get talking Netflix. We tried. Lainey's so successful in this, but we're not. We tried talking. She says, put out an open hand. We tried that. And we met together with Netflix, and they're like, well, what are you asking for? What do you want captions on? We're like, everything. They're like, well, that's just not even within the realm of possibility. I mean, that's just ridiculous. And, even after we went out of the meeting, I have to say that some of our own colleagues, not to mention any names, were like, well, this is a loser because they already have like 30% captioned. And then they'd be like, well, so what do deaf people like to watch? It's like, the idea of the ADA is full and equal access. So if I like to watch some weirdo show that not many people want to watch, and I'm hard of hearing and I need captions, then I need that show. And every time I gave myself as an example in my non-mainstream taste, they would always say, well, it's not about you. I'm like, but I'm not the only me. There's a lot of people, deaf people are varied. They don't have like the Deaf Academy Awards of like. So we were told by everybody, including our closest colleagues, that it was a case that couldn't be won. But we decided with our main client being the National Association for the Deaf to try for it. And so here are the biggest hurdles. First of all, Netflix is an internet-only business. It doesn't have stores. That was the biggest problem. And there was very bad case law around the country on internet only. I mean, there wasn't a lot. There's very little, actually, but what there wasn't good. The best we had was in California and the Ninth Circuit that if you had a bricks and mortar place, and then you also had an adjunct internet site, that it would be covered, but there had to be a nexus. So there was a nexus requirement. requirement in the Ninth Circuit. So we decided we're not filing in the Ninth Circuit. And we went for where can we file that would be conducive, or we'd have a chance, basically. And through a lot of, I think they call it forum shopping, that we looked at, there was nothing that said an internet business only was covered, but there were a couple circuits where they hadn't said it wasn't. And in the First Circuit in particular, they had said there were cases that kind of gave rise to the idea that you didn't have to have a building. So our big problem was that the whole section is called places of public accommodation. So we decided that, when we look at Massachusetts as a place to file, and then we, talked to a lot of people and decided that we wanted to be in Western Mass. And so there were a lot of people in Western Mass who were deaf and wanted to watch Netflix, as it turned out. So we were able to have plaintiffs from Western Mass and the National Association for the Deaf. The next thing was that, the next hurdle was that it's entertainment in your home. And so the idea was, well, but that's not a public, so it's places of public accommodation. So both of those things seem to be against us. And then, of course, there was the fact that Netflix is just taking other people's products, other companies' products, studio products, and running them on their site, but they're not producing the product. And there's this little pesky, are there any defense attorneys here? You? Uh-oh. Well, there's this little pesky provision of the ADA, which we don't like to get out very much, but it says that you don't have to modify goods in order to make them accessible, because it was considered just too much of a floodgate. And the example that's given is that a bookstore, you don't have to have every single book, and the bookstore owner does not have to have every single book in the bookstore in prayer. And so, one of the examples they used too was you don't have to have every video in the video store with closed captions. So we're like, okay, what's the difference between that provision that an exception, we call it an exception to the ADA, and what we're doing? And the big difference was, this slide is about what I just said. No place of public accommodation. The ADA was intended to increase access to the community. It wasn't in the community, it was in your own home. So the biggest thing that we developed was, first of all, on places. If you look at the places that are listed, the 12 categories, what you can see is that basically what Congress was trying to do is say that disabled people should have access to the goods and services that everyone else has access to. And the reason why they made a big deal out of the fact that this went through many motions to dismiss this case. Then why isn't the internet covered? Well, the internet wasn't covered because it didn't exist, basically. I mean, the Department of Defense had a computer the size of this room or something. So it really wasn't, no one could possibly have anticipated. It's interesting to think about now, in 1990, what the role the internet would play in our lives. And this YouTube site is just a fun one if anyone wants to watch it at home, because it's Brian Gump, the Today Show, and they're going so what's this thing? It's like a dot, something dot, and it's just, and that's in 1990. People didn't know what it was. So we were arguing that the things that are listed, the important point is that the things that are listed are now on the internet. We said it's not a good, because it's not just, it's different than a bookstore and it's different than a video store, because what Netflix is selling isn't that product really, but the service of being able to get it instantly. We said integration is still implicated because even though it's done in your home, it's first of all not only done on your home, because people can do it on laptops and people can do it at home with their families, and our plaintiffs in fact had great stories about, I'm a parent of kids, and they were saying to me, Daddy, what's this show about? And I can't tell them, and the opposite way around too, where the deaf parent and the hearing kid. So we said, it's not really just a private enterprise, and also it's a buzz. It's like, it's in the culture, so people talk about it. So in order to do that, in order to make that case, we used Netflix's own statements. And what we really used the most was their advertisement. Watch what you want, when you want, by streaming instantly over the internet. And so the idea being that that's what they're making, that's their deal. Their deal is the service of the watching instantly. And we also were able to use their, got 1 minute. They're also able to use their pictures from their own advertisements of like the family all cozied up on the couch watching together, so it's not a solitary activity. And then they actually, whoever put this next one up on the internet was going to be in big trouble, which is this. So they show that like here you are on the school bus and you're both watching Netflix. So it was a social activity. The judge agreed that it would be absolutely illogical. It would defeat the ADA if you did not cover the kinds of activities that are listed under public accommodations when they move to the internet. That it would be illogical, that it would completely undermine the purposes of the ADA. And that was like, that decision was big. It was fantastic. And after we got that decision, we were able to settle with Netflix. We were able to have structured settlement with Apple. All Netflix and all Apple iTunes products should have captions. And we're in negotiation with others, and it says, stop, please, like to be nice about it. Anyway, so I just end by saying that that's Netflix, and like I said, we've been able to carry it through to Apple iTunes. That was a collaboration. We're negotiating with all the streamers, and now everyone's streaming. But what's also really important in other contexts, and the big thing we're working on now in our big initiative, is education. And it's, all of you know, it is wonderful how much is available on the internet. It's also scary how much is going to go to the internet about education. And if we can't get captions on that, talk about being closed out and having a whole new era of segregation, having a whole new era of isolation, lost opportunity, etc. It's when education goes to the internet and people who are deaf and hard of hearing can't take advantage of it. And Hamda's going to talk about blind people as well. Would we do those cases also? And it also comes up in healthcare. They're doing a lot of healthcare videos on the internet. And it also comes up in employment, because more and more employers are using internet for training purposes. So it's just huge, and it's a really important thing for the disability movement and lawyers to be very vigilant about, because the internet is supposed to be the biggest boon for disabled people. It's supposed to be the biggest breakthrough to opening the doors of society, and it could end up being the biggest barrier we've ever found. Thank you.
What are the yellow pages? I just had that question.
That's a good one. That's a good one.
Yeah, that's it.
Really?
Okay. All right, you should be ready
What?
now. Your slides are ready.
Yeah, exactly. Now we wouldn't be using the yellow pages. A good point.
Or maybe this too.
She won't use them.
Okay.
Do I use this one to switch it?
Yeah, that one is for work.
Yes, that's correct.
Okay, cool. Thank you. Good afternoon. My name is Haben Girma, and I'm a Skadden Fellowship Attorney at Disability Rights Advocates, DRA. And we have an office about 3 blocks from here in Berkeley and another office in New York. And we do high-impact litigation all across the country, representing various disability groups like the American Council of the Blind, National Federation of the Blind. I decided to go into law because as I was growing up, I saw technology and businesses change how people connect with each other and with services. And I saw access barriers coming up for the deaf community, for the blind community, and the deaf-blind community. I'm deaf-blind myself, low vision and low hearing, and use technology constantly for my work, for communication. So I wanted to use the law to remove these access barriers and increase equality for all of these disability groups. And the law is an excellent tool for that. We've seen the law used to get captions for Netflix so people can watch movies. One of my favorite cases at DRA since starting is a case to gain access online for blind individuals to read books. Books are absolutely critical for everything from school to leisure, to staying informed and being engaged citizens. So access to books is really, really important. And it's the next level and next step of the Netflix reasoning that we just learned about. Access online means many different things. The World Wide Web Consortium came out with the Web Content Accessibility Guidelines. And these guidelines teach programmers and web developers how to build websites and apps that are accessible to people with disabilities. For the blind community, that means having websites that are compatible with screen readers. Screen readers are applications that take visual information and convert it to audio or digital braille. And it's fairly easy to code a website if you're doing it from the start and you're aware of these guidelines. So the more web programmers who know about this, the more accessible websites can be. So access for screen readers for the blind community is one component of access online. Another component is closed captioning or transcripts for individuals who are deaf or hard of hearing. Lots of videos online. I gave a TEDx talk earlier this year, and TED posted that talk without captions. So I told them about the Netflix case and did my best to educate them. And they finally did add captions for my talk so that everyone can access my own talk. But there's still many, many, many talks on the website, on TED's website, that are inaccessible. So there's so much more to be done in this area of ensuring that deaf and hard of hearing individuals have access to audio content online. The Web Content Accessibility Guidelines provides instructions for programmers for providing captions. For individuals with mobility disabilities, it's helpful to have keyboard shortcuts, and those guidelines provide instructions for that too. So the more people know about this, especially developers, the better. Sometimes people know about it, companies know about it, and don't do anything. And that's when it's helpful to have advocates to come in and encourage them nicely and through litigation to make those changes so that everyone has access online. There have been several cases to apply the Americans with Disabilities Act online. Some successful, like the Netflix case, some not so successful. One of the earlier ones is called Access Now versus Southwest Airlines. And the court in that case said websites are not physical places, and places of public accommodation under the ADA are only physical places. So they ruled in that case that the website for Southwest Airlines did not have to be accessible to blind individuals. In another case, National Federation of the Blind, NFB, versus Target, the Target website was inaccessible. Blind individuals wanted to shop at Target.com. Blind individuals wanted to give their money to Target, and Target said no. So disability rights advocates, National Federation of the Blind, filed a lawsuit against Target. And in that decision, the court held that the Target website is a service of the physical Target stores, and there was a nexus between the virtual service and the physical store. In the Ninth Circuit, here in California, the ADA is limited to physical places. But in other circuits, it's not, like the First Circuit, where the Netflix case was held. In July of this year, the National Federation of the Blind filed a lawsuit against Script in the District of Vermont in the Second Circuit. Script is an online reading service. It has over 40 million documents. A lot of those are ebooks. And these are available through their website and apps for Apple devices and Kindle and Android devices. And it's all inaccessible to blind readers. Sighted individuals can access this by paying $8.99 a month. It's very similar to Netflix in that you pay a monthly fee to get unlimited access to all the books you want, reading them when you want to. We have online bookstores like Amazon and Apple iBooks. And now this is a new service. It came out last year to offer subscription services for access to books. But this new service is not accessible to blind individuals, and blind individuals want to be able to read. And this is something everyone can relate to. Everyone understands the importance of reading for work, for education, for self-growth. One of our plaintiffs, Heidi Veens, is a mother, and she wants to be able to access books to read with her daughter. But that option is not available to her through Script. The National Federation of the Blind has blind members all over the country, in every state. Blind individuals who are teachers, students, lawyers, all who want the right to read through Script services. So we filed a lawsuit to seek to transform the Script website and apps so that they're compatible with screen readers. The Web Content Accessibility Guidelines have been around for years. Script was founded in 2007. They've had a long time to figure this out, and they haven't. So we sent a letter to them, and they ignored us. So we filed a lawsuit, and in October, they filed a motion to dismiss. And their reasoning is that script is not a physical place, and the ADA only applies to physical places. And they cite Access Now versus Southwest Airlines and NFB versus Target and every single case they could think of to try to argue that their site should not have to be accessible to blind individuals, and blind individuals shouldn't have the right to read on Scripps services, on Scripps websites and app. Right now, we're in the process of writing our brief opposing the motion to dismiss. And we're excited to bring one more positive case that shows that online businesses need to take access seriously. It's not an option. The ADA, though it was written when we weren't using the internet, still applies to the internet. And Arlene provided many great reasons why that is. And the Netflix case relied on a decision from the First Circuit called Car Parts. And that decision has been referred to and cited very positively by the Second Circuit. So we're very, very excited to bring this case and help increase access to reading online for blind individuals. There are many reasons why to care about access online and the Web Content Accessibility Guidelines. One reason is the law. Websites, online businesses are generally not limited to physical places. They're not limited to just California. So these websites are being used in Massachusetts, where we have the Netflix holding. And they're used in Vermont, where we filed our script case. So these decisions are affecting online businesses, and it's important to understand the law and program websites and apps because of the law. It's also good practice to get more customers and do what's necessary to increase the number of subscribers you get or the number of customers who shop at your store. And it's a good practice to think about how to make your services accessible to everyone. And I think we're opening questions and answers now. So thank you, and looking forward to your questions.
Thank you. Thank you, Hava, and thank you, Arlene. We do have some time for questions and answers, so if you'll raise your hand, I'll take some of those. Perfect, and we'll send a microphone out to you. Thank you.
Thank you. I love your presentations. You all are great. One thing that I was thinking is how much also, I mean, Arlene, if in the case of Netflix, for example, anyone saw actually like all the movies are captioned in other languages to go to other countries. I mean, I grew up actually with all the movies with captions in Spanish. I went to the movie theaters in Mexico, and every single theater always was captions in Spanish because they never had, the translation. So I don't think that actually it's that impossible to do it because they are captioned, or they would miss the global market. And in order to translate it, they needed the script in English. I mean, I translate. They are not, So just that question. And the other thing is in regards to making, the websites accessible. So I think that there is one very important piece of information, this connection in this process, which is there the career? I mean, like when you are redefining your career, I love technology, and I've been looking at assistive technology and finding out it's so hard to find the training on assistive technology. And I don't think that there is a training actually for making these places accessible. And I think that, I mean, because just recently I have seen a lot of jobs posted like Google and Yahoo, and if you open Craigslist, there is like, they're looking for people to make their websites accessible, and they have been posted for months because I don't think that the career actually exists. Oh, well, it needs to be promoted, my dear.
Well, does someone have an answer there? Yeah.
Okay. It's user experience and usability. It's a newer field. It's much newer. There's a big, in Texas actually, there's an organization called Knowability where they train companies to teach people how to make products more accessible. It's very small, but they've been around for a long time. And then information technology is in a lot of library schools, and they work on usability too.
Can I just add one? As we know, another big problem in our community is employment. So I think this right here, there is an opportunity to open a job for people with disabilities, training in a department that actually benefits people with disabilities. Department of Rehab should be on the table.
There you go.
Just quickly, my husband is a user experience engineer, architect. They're architects now. At Oracle, and Oracle does a lot of this because of Section 508. When they have things for Department of Defense, they have to make usable websites for everyone.
First, I want to say that the litigation that DREDF does, DRA does, is really important to the structured negotiations. So I just want to say structured negotiations is a strategy for, it could be used for any number of disability rights issues. We've happened to use it in web accessibility and mobile accessibility, but it's not to say litigation is not another great strategy. So I don't want anyone to feel just because I do structured negotiations. But with that said, I think because in part of the great litigation work that DRA and DREDF do, that we've been able in structured negotiations to go to companies, and there's a very realistic chance that they could lose a litigation. And with that possibility, they have been open to participating in a non-adversarial process. So we've done web accessibility agreements with Major League Baseball and Weight Watchers and Bank America and CVS. We have like 25 of them. And in part, it's because we write a big opening letter, mostly focused on what Haben's talking about and what Arlene was talking about, that this matters for people with disabilities. And by trying to keep it out of the law departments and get it into the development departments as soon as we can, the companies are willing to deal. And there is a whole world, I don't know how many people are here on Twitter, but there's a whole world, Alicia, to your question, of consultants and activists, and they use the hashtag on Twitter, A11Y. And it's 11 because there's 11 letters in the word accessibility, and Twitter you have to keep short. So if you want to see what's going on in this space, you can follow that on Twitter.
I'm going to steal the microphone just to ask a question of myself again. I have a question that goes to accessibility in general and not specifically into the internet, but it's, Article 3. So Haben talked about the economic development and the economic strategies and, businesses getting more customers with disabilities and increasing their business, right? Targets want more people with disabilities getting products from them. But I'm wondering about what would you say to small business owners and I'm not talking about the internet, I'm talking about small business owners, small stores. Well, when the increase in customers with disabilities is not very beneficial for them. So I was wondering if there's a strategy to get into those, small stores owners who also needs to comply with the ADA, and what would we do with those store owners? How can we get them, maybe not through litigation, maybe through other tools? How do we get to them?
So having your website be accessible can actually be very, very easy and not expensive at all if you start out with accessibility in mind. There are web templates out there that you can use for your website, that small businesses can use for their website, that would ensure that their website is accessible. So it's just a matter of approaching online services and apps with accessibility in mind. So it's expensive if you build an inaccessible website, then have to tear it down and rebuild it from scratch with accessibility in mind. But if you do it from the start with accessibility, it's just a matter of using the right code and not expensive at all.
Were you talking about physical access?
Yes, also, yeah.
Yeah, I mean, that's important to know. And I think that let me just go backwards to say that even for the big businesses and 36 million consumers, how can anyone turn their head around for 36 million consumers? But I don't know, maybe Lainey, you've had more, like you're saying, getting out of law, the legal department and getting into development. But when we talk to lawyers, it's like you have said nothing. It falls on...
Oops, don't say it.
Don't say it. No, I mean, they don't believe you. And it's so obvious. But the other thing I wanted to say about captions is there's been a study that came out in England, actually. 80% of the people that use captions are not hearing impaired. Captions just happen to be good business. They're wonderful for a lot of different uses. People who are learning a second language love captions. A lot of people say that's how they learned the language. Well, you kind of saying that. It's great for parents. I have so many parents of young kids who use captions because they don't want to wake up their kid. There's so many uses. And also nowadays, the way TV is so frantic, it's like people miss things all the time, and they love the idea of being able to go down and check what they heard. They're used by a lot of people. So the big business motivation should be obvious, and it should be a big seller in our field. But at least from the meetings I have, and maybe it's because it's with the lawyers, it's just, and it's not only sometimes with the lawyers, it's also with the principals. They don't seem to think it's a customer base, which I think is very strange. The ADA, for small businesses, this is getting to the small businesses, the ADA doesn't require as much of a small business as it does of a larger business. The ADA, I mean, it kind of corrupts the equality model, but it does have the idea that the bigger you are, the more you have to do. And I think it was the most even-handed kind of legislative approach because you can't have small businesses maybe it isn't in their economic interest, but it's a civil right. So, it might be that you can't use the economic argument. The other thing I want to say about subtitles, just to make sure everyone knows, subtitles and captions are different. And captions, the difference is that captions describe audio sounds in a way that subtitles don't. So if music playing, and even more specifically, Mozart playing, door slamming, that's a very important part of captions. And in fact, in all of our negotiations, one of the big, I would say, compromises that we've made is that if something's already subtitled, we're allowing them to keep that. But that's a big compromise for the deaf community because you don't know until you're deaf or hard of hearing or don't. In so many areas in disability, you don't realize how much information you're getting auditorily.
One follow-up comment on that? Yes, please, go ahead.
There is someone in San Rafael who actually has a business for people who are blind, and the movies have description for the blind, and I think that's a segment that we're forgetting. If we're only talking about people who are deaf, we have to remember people who are blind, who are not seeing what we're seeing, like so many silent moments in the movie that are essential to know what's going on.
Yes, exactly. And so I don't know to what extent there's actually been litigation on description, but description is a huge area. And there's a lot of innovative things being done about description because description can be very subjective. And so Josh Mila, who's someone who is very much at the epicenter of the idea of crowdsourcing description, so that you're getting descriptions from a lot. You can have your favorite describer.
I have a quick. Oh, go ahead. It's called You Describe, and anyone can go and choose things you like to watch, and the technology is right there for you. Anyone can learn it, and you can describe anything. And even if someone else has, you can make your own version.
And it's a really good thing to do, because the thing about description that's really interesting is that people emphasize different things.
That's a fantastic plug. I want to say thank you to our panelists and to everyone here. Unfortunately, we're out of time, but thank you so much. It's now time for some brief closing remarks from Laverne Jacobs, and then there'll be a reception after those remarks.
I'm not Laverne. Good. You definitely get the last word.
I'm going to say some thank yous, and I'm going to concur with you, probably.
That's cool.
Oh, thanks. It's a lifesaver. Yeah, it's so easy to use. Yeah. So whenever you want to start, go ahead. And
Okay, I think we're going to get started, so you all can be released into the reception. I'm not Laverne Jacobs, obviously. I'm Sue Schweik, and I also was asked to do a few closing remarks. And I was non-compliant because I was asked to just choose one thing, and I just couldn't. So and let me just say, of course, like everyone in the room, I've certainly been thinking about the question articulated early on, what do we do now? And I'm so grateful to the panel that just preceded. It's such a wonderful example of how do we move the dollar bottom line, to quote Ella. And I love the Yellow Pages story. It's like follow the yellow brick road. Just totally great. But I also, that being said, I think I'm also going to be a little bit of a downer, or to quote Ella again, as someone who drills down, maybe that's a better way to look at it. I was thinking while I was listening that disability was there at the dawn of the modern international human rights initiative. Rene Cassin, who drafted the Convention on Human Rights, it's commonly understood when people think about what gave him the impetus and the knowledge and the wisdom and the drive to do that, people oftenly think about his World War II resistance and his imprisonment.
but less commonly think about the fact that in World War I, in order to get medical care, he had to hike many, many miles holding his intestines, which were spilling out because he was not given care. And he organized disabled vets after World War I who would do limping marches, no matter what their disability was. They all limped, or whatever they did, to simulate limping together. Human rights from the outset was a disability issue. And at the same time, here we are on the ground. I've been thinking about Eric Garner today, and what on earth what we are talking about answers to that voice saying to us, I can't breathe. Few themes that I thought about. One is interdependence, of course, and also co-constituency between people, all the different examples of human interaction we heard about, and also between and among laws and processes. So international and domestic co-constituting each other. Litigation and structural negotiation, proactive and reactive, adversarial and procedural, rights-based and needs-based. And also thinking about what toggling between the US and Canada can illuminate. I find this example, this is such a typical American response, but this moment today, hearing that human rights tribunals have sometimes been used in Canada to handle special ed cases, this is just mind-boggling. I just want to mark it for the Americans in the room. Sorry. Been thinking a lot about the relation between law and process and procedure and the commonplace. And thinking when Carrie, for instance, talked, or when Laverne talked about transportation hearings being a place where people's voices, their own voices, actually got in the room. I was thinking about what Carrie Sandall, another Carrie who is a disabled parent of disabled child, is talking about when she, under the rubric of TMI, too much information, the things that are said behind closed doors, but actually there is no place in disability advocacy or in the courtroom or in the IEP conference to talk about these things. And how do we keep on getting too much information in various ways? This is the English professor me talking, because I think one of the main ways we do it is actually through literature and through culture. And finally, I just want to say that whatever we do next, I really trust this incredibly conscientious group. And I want to invoke Stephen Taylor again and his books, Acts of Conscience. And just thank you all for being actors of conscience. It's just been very exemplary to me today to watch the different ways that people are seeking justice and seeking a perception of the real and truth and acting on it. So thank you very much, and I'll turn it over to our master. What's the master? What was the phrase? Our special master.
Well, we should thank you first, Sue. Yeah. Well, you know, I always love Sue Schweig's wrap-ups. I've got to say that. They are always very thorough. She's so thoughtful. I don't have much to add. I want to just move on to thank you. You guys have thanked me, an embarrassing amount today, and I just want to now thank you. Thank you so much for coming today. Thank you so much for the discussions we've had. I've really been engaged with your thoughtful ideas and your back and forth, your ideas. It's been wonderful. I think it's safe to say that it's been a successful event today. We've had stimulating sessions, important questions, important themes. I want to thank all of the speakers who came out for taking the time to prepare papers, presentations, and to just to attend the symposium. The papers will be published in the Windsor Yearbook of Access to Justice in 2015. 2015 will mark the 25-year anniversary of the ADA, as we all know, but it also marks the 10-year anniversary of the Accessibility for Ontarians with Disabilities Act. So it's a very special year. Thanks to all of the moderators. It's not easy to facilitate panels, and the moderators did such a fantastic job with really, really thoughtful and insightful comments. I really have to thank you for that. And thanks to all of my Berkeley colleagues with whom I had the pleasure of working this past year, Sue Schweik, everyone, Irene Bloomrod, Rita Ross, Roseanne Greenspan, who are all on the planning committee. It's really quite an honor for me and very humbling that you would allow a visitor to come from Canada and organize a conference and that you'd support me in this way. So thank you very much for your support and for working with me to organize this conference. I want to say a special thanks to Rita Ross for all of the logistics. Rita, I always describe Rita as kind of the longtime emissary of the Canadian Studies program. She's been with Canadian Studies for a while. Rita's actually retiring this year, and so I know Canadian Studies will miss her, and I want to thank her for all of her work and all of her support and just being there and being a great colleague. And so last but not least, thanks again to all of you for attending today. A conference can't be made successful without people who come out and attend, and you've come from many faraway places and also from locally, and we all appreciate that. So thanks. So we now have a reception over in the Goldberg Room.